Good morning, everyone. Welcome to the Committee on Veterans and Legal Affairs. Today we're assembled electronically to work through our agenda, which has a number of work sessions. But before we get into the committee's work for the day, we'll begin with committee introductions, and we'll start with the House Chairman Chiazzo.
Thank you, Mr. Chair. Good morning, everybody. Chris Chiazzo, House District 28, beautiful, sunny, warm West Scarborough.
Senator Farron.
Good morning, everybody. My name is Brad Farron. I live in Norridge Walk and represent Senate District 3, which is the majority of Somerset County in the town of Rome and Kennebec County.
Representative Corey.
Good morning. I'm Patrick Corey, represent House District 25, which is part of Wyndham.
Representative Wood.
Good morning. Hi, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula.
Okay, Representative Supika.
Good morning. I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Dolph.
Oh, good morning. Representative Josephine Dollar from District 115 in the Western Mountains, Roxbury, covering Roxbury, Rumford, Milton Township, with Sumner.
Representative Tuttle.
Representative John Tuttle, District 18, part of Sanford. Mr. Chair, bear with me today. I've got meetings up at City Hall. I'd already advised a good co-chair about that, but please bear with me.
Thank you for the heads up, Representative Tuttle. I think it's a busy time and we're all bouncing in and out, but appreciate it. Representative Riley.
I'm Representative Riley. I represent House District 34, which is part of Westbrook.
And Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Great. And my name's Louis Lucchini. I represent most of Hancock County in the Senate. With us today, we have our committee analyst, Janet Stocco, as well as our committee clerk, Karen Montel. And so on our agenda today, we'll begin with a couple of language reviews to get them kind of out of the way and working through the pipeline. But then I think the plan will be just to start on some of these gambling bills. I know it's a new topic for a lot of people, so I'm thinking we'll probably begin with the sports betting bills and then work through the list from there, as we've got a number of proposals, and we can probably break to caucus at some point just to give people some time to catch up on all the information. So I think we'll begin with language reviews. Janet, if we're ready.
Sure. Can you hear me? Did I unmute?
Yep, you're good. Thanks.
How unusual. So the first one, which is not cooperating, is LD 591, which is the Representative Chiazzo's bill about the number of agency liquor store licenses. The majority report was straight ought to pass. So the fiscal note only request said there's no fiscal note required, so that will stay straight ought to pass. And these are the members who voted for it. I tried to blow it up, but it wouldn't let me, so you'll have to like squint. Then there was the largest minority report was ought not to pass, but then there was a one-member minority report which follows the bill, except that it strikes the increase in the number of agency liquor stores for towns with a population of over 60,000. And so that's what this amendment is. This is that one person minority amendment. It does have a fiscal note required, but it's just to mention that it's a minor revenue increase. So it's not one that's like hard to overcome. I can't think of the right words, but you know what I mean. So is everyone okay with 591?
Sure. Is everyone on the majority good with that? Or Representative Corey, are you good with yours? Good. Okay. Thank you, Janet.
Okay. Just gonna check that off here. The next one is LD 671, which is an act to allow the sale of raffle tickets online. You may not remember because it was a while ago, but we did actually have a preliminary language review on this one where it was the creation of a slightly different approach than the bill took to online raffles. But because you may not remember and because I don't necessarily always remember everything, I did kind of annotate this amendment to just remind you. So the bill allows nonprofits to have raffles that they sell the tickets online. The majority, which is everyone, I believe, but one member, and then there was one member absent who didn't cast a vote. So everyone else voted to create this new license for an internet raffle operator, which is the type of organization with the experience and the know-how to conduct these online raffles. And that's what these two provisions of the amendment do. They define the internet raffle operator and then their system that they use to conduct that online raffle. Then the next part of the amendment creates the $500 calendar year licensing fee for such a new licensee, the internet raffle operator itself. There's a provision in the games of chance law that says you have to conduct your own games of chance if you're a nonprofit. And so there's an exception to allow them to hire the internet raffle operator to conduct that internet raffle. That's what this provision is. This is just a cross-reference change. So then this part, section 10 of the amendment, requires an eligible organization, which are your charitable organizations, to register if they're going to be conducting an internet raffle. They don't always have to register their raffles, but you all had decided that if it's going to be an internet raffle through the licensed internet raffle operator, you wanted them to register with the Gambling Control Unit. So the Gambling Control Unit would have some oversight. So that's what this provision requires, and it also restates the requirement, which is going to be mentioned again in this amendment, that they can't sell raffle tickets to persons under 18 years of age. And then this is the new provision that's going to be created in statute if the amendment moves forward to require the licensure of these internet raffle operators. It clarifies that they can't conduct internet raffles on their own. They have to be doing so on behalf of the charitable organization. They have to submit background check information so that the Gambling Control Unit can investigate their background before issuing the license. And then their system that they use to conduct the internet raffle has to be certified. So it has all of these requirements, which we went over before, including no use of credit cards, requiring you to be at least 18 years of age, making sure you're physically located in the state to purchase a ticket, using a random number generator to select the winning ticket, and providing some security and privacy protections to the purchaser. And then maintaining 3 years worth of records and making sure they give the records to the nonprofit about who purchased tickets and who won. And then the last part of the amendment would require that the internet raffle operator itself not receive any more than 10% of the proceeds of the internet raffle. When I originally drafted this amendment, I didn't know the final vote. So the only thing that I'm going to have to change is add that this is the majority report of the committee because there is one vote against it now. We were going to do language review earlier, but the fiscal office wanted to look at the fiscal note again. So this is the revised fiscal note. You might have seen the other one somewhere earlier. I doubt it. They're hard to find, but this is the revised fiscal note. This is the one that will be attached to the amendment, and it indicates $66,000 estimated increase in funding in the first fiscal year and then higher moving forward based on new application and registration fee revenues for these internet raffles. So is everyone on that report okay?
Yeah, thank you, Janet. That looks good to me. Does anybody have any questions or issues with that one? Right, thanks. I don't see any hands.
The next one is LD 941, which is an act to protect the privacy of absentee voters. This is the minority report of 5 members of the committee. Originally, this was the bill that required the privacy sleeve, but it was changed. So if you remember, under current law, when they process on election day the absentee ballots. They have to take them out, and under the law, they can't unfold the ballot right away, and they take it out of the return envelope. And the majority amendment to 941 would add language saying that they have to have at least amassed a group of 10 folded ballots in a bin before they could unfold them to finish processing them, unless it's at the very end of the election day and there are less than 10 left, and then they can unfold less than 10 at a time. So this is the provision of law regarding processing on election day. This is the provision of law regarding early processing of ballots, and it just adds in that same requirement that you have to have a group of 10 or more before you unfold the ballot. And if there's less than 10 at the end of the day, then you just don't process them and carry them forward to the next time you do process ballots, which might be on election day itself. There's no fiscal impact. So I'm just pausing here for people to look at this language if they're on that report. Again, just about keeping the absentee ballots folded until they're in groups of 10. And so because there's no fiscal impact, you won't see this attached to the amendment when it goes to the floor. I just wanted to show you that it had been evaluated and that had been the determination. So is everyone okay with that?
Okay, is everybody good on the, I think it's minority report on 941? That language?
Okay.
No questions? Yeah.
All right, and then the last one for today, hopefully we'll have more Friday. This is the one you just voted. An act to support Maine theaters by expanding eligibility for off-premises catering license. This is LD 1620. This is the bill that says that an auditorium, civic auditorium, and a performing arts center can have an off-premises catering license. And the only thing that you did was add an emergency preamble. So that's here. And it adds an emergency clause, which says that it actually takes effect when approved. There is a fiscal note required, which is also a minor revenue increase fiscal note. So that should allow it to progress fairly steadily through, depending on how you all vote in the chambers.
Great.
Is everyone okay with that one?
Yeah. Great. Thank you, Janet.
That's
Great.
the last one of those. So do you want to start with sports betting?
Yeah, I think so. Yeah. Thanks for getting those going so we can hopefully get them ready when we have session next. So yeah, I think it would be helpful to start with the sports betting discussion since we have 4, pretty big bills with different proposals. It would be good to walk everyone through all of those.
Just getting the right thing on my screen.
Yeah.
All right, so just to remind everybody, this is the electronic committee LD file. All the sports betting ones are on the same page because they were all heard the same day. And for each bill, you're going to find the bill analysis, which is the same for all of them. And then an appendix. I just want to show you the appendix. I'm not going to go through it all, but our researchers combined to do a crash course on all states with legalized sports betting. And they hyperlinked all the statutes here if you want to read them yourselves. But I did ask them specifically to investigate who can have the licenses. So whether there's tethering required is sort of a subplot of this column. The types of bets that are allowed, and then the tax rate, because those were the things I thought might be of most interest to you. And then there's like a quick summary, some bullet points of the numbers of states that do different things at the bottom. So that's just background information for you that we thought might be helpful.
Awesome. That's really, really helpful. That's great.
Yeah, they really do amazing quick work. So I was super impressed with it. So that's Kristen and Darlene. If you ever see them, say thanks.
Right, will do.
Okay, so all 4 of these bills would authorize the Department of Public Safety Gambling Control Unit and the Director of the Gambling Control Unit to regulate sports wagering in the state. And where this is a new entire regulatory scheme, I did not know which details would be interesting to which members of the committee. So unfortunately for you all, you're gonna have to listen to me for a long time because I summarized it all. So
That's great. No, I think it's super helpful to have a good analysis because we have, I mean, we have a lot of new people and it's like, I forgot half of this. So it's great.
okay, so the main two types of licenses are facility operators and mobile operators. So a facility sports wagering license authorizes the acceptance of sports wagers that are placed by customers within a physical location in the state. And a mobile sports wagering license authorizes acceptance of sports wagers when they're placed through a mobile application or digital platform that's approved by the director, and they have to be placed by customers physically located within the state. And that's actually a requirement of federal law that we're going to talk about later, which is why that's in there. At least that's my understanding of why the bill sponsors put that in there. And then there is a provision under the facility operator license statute that says that municipalities retain their home rule authority to enact zoning and public safety ordinances related to the location and operation of sports wagering facilities. It doesn't write it exactly like that, but that's what that local control provision means. And by the way, these are just the common features. So you may be wondering who can have these licenses, and that's actually a distinction between the bills. So I will get to that. I'm only discussing the things that are in all of the bills at the moment. So management services license, all four bills provide for that. So an entity would have to just demonstrate to the director sufficient sports wagering knowledge and experience to obtain a management service license. And if it gets one, then a licensed facility or mobile operator in the state may contract with this licensed management service provider to manage its sports wagering operations. So for example, if you're an OTB and you have a facility sports license or even a mobile sports wagering license, you don't have to conduct it yourself. You can contract with a management services provider, but you have to make sure they have a license themselves first. And then the written contract and any substantial change to that contract between the management services provider and the facility or mobile operator has to be approved by the Gambling Control Unit director. And all of the bills state that subcontracting of the management services provider's responsibilities to any entity that's not licensed is prohibited. There are also supplier licenses. So only suppliers with those licenses can sell or lease sports wagering equipment, systems, or services to state operators. And those equipment, systems, or services have to conform to standards that are established by the director by rule, although the director is authorized by all of the bills to by rule decide that he would accept another jurisdiction's approval. If that's the standard, that's fine. In addition to having to meet those standards, the supplier can only sell or lease its equipment, systems, or services if it's been approved by an independent testing laboratory, and that laboratory itself has to be approved by the director. So the licensing fees under all four of the bills are based on 2-year intervals, with facilities, so that's in-person operators, paying a $2,000 per 2-year term fee. And then the mobile operators, the management services providers, and the suppliers all paying a $20,000 per 2-year license term fee. I see a hand, and I don't mind stopping now if that's everybody's preference.
Yeah, whatever works best for you, Janet. Do you want to stop as we go?
Sure.
Okay. Representative McCray.
Thank you, Mr. Chair. Thank you, Janet. I'm looking at number 3.
Yep.
Independent testing, and I'm still thinking all the marijuana bills.
So
what are we talking about with a testing laboratory? What are they testing?
Well, I believe that the director is here. That may be a better question for him. I can only tell you what we were told in the 129th, which is there are nationwide known and reputable laboratories that do test gaming equipment. And the director would select one or more of those as being able to test this equipment to make sure, for example, it doesn't, claim that it gives you a 5% return, but only give you a 4% return and keep the rest of the money for the operator or something like that.
Thank you. I get it. Appreciate it.
And we do have Director Champion, if you wanted to add in, just as the ins and out of the industry.
Yeah, John explained that really well, though. But the supplier license is basically the equipment and all the idea of taking the wagers and processing everything. So typically, independent labs that do this type of thing would be like Gaming Laboratories International, which is worldwide. BMM, Nick Farley, there's a few test labs that would have the ability to do that.
I think it'd be similar to like weights and measures. We're making sure they're accurate.
Yeah. In
Yeah.
fact, these same laboratories also do our slot machines and table games, progressives, and that sort of thing.
Thank you.
Yes.
Great, thanks, Director.
So the next part, number 5, for all of the bills, remember we're talking about these are all the common provisions. For all of the bills, applicants for one of the licenses described above have to disclose the identities of and consent to fingerprint-based background investigations of the applicant themselves, each person that owns at least 10% of a corporate applicant, if that person has the ability to control the corporation's activities. If it's a non-corporate applicant, then each direct or indirect owner who the director determines has an ability to control the non-corporate applicant's business operations, and then also all key personnel with significant influence over the relevant business operation. So in conducting this background check, including the fingerprint-based background check, and deciding whether to issue the license, the bills all lay out the same grounds for denying that license, and it could also be for denying a renewal of the license because things might change over time. So that would include knowingly false statements on the application, including failure to disclose required information. For example, if you had a silent partner you didn't want to disclose, that would be a problem and could be a grounds to deny the license. Any past revocation of any gambling related license by any government authority for any one of those individuals, any past felony conviction or other criminal conviction or civil violation adjudication that involves dishonesty, deception, misappropriation, or fraud, any past conviction for gambling crimes in any jurisdiction. Also includes being a fugitive from justice, drug user, person with a substance use disorder, illegal alien, or dishonorably discharged from the U.S. Armed Forces. Again, these are possible grounds. It's not mandatory grounds for disqualification. Not being current in the filing or payment of federal or state taxes in any state. Not being of good moral character, which sounds like a nebulous term, but the bills all follow that up with examples, including evidence of dishonesty, lack of fiduciary care, and there are some other examples in each of the bills. They're all the same as each other. Lack of demonstrated financial assets or financial responsibility, and then violations of any provision of the sports wagering laws or rules in Maine. And that last one is probably most related to renewal applications. So if you have a facility operator license, for example, and then you violate some of the provisions, that can be used in evaluating your renewal application. All of the bills also provide for temporary licensure. So during the whole background investigation process, which might take a while, there is this provision that says that the director may issue a temporary license upon payment of the initial license fee, as long as the director is not aware of any reason the applicant may be ineligible, and the applicant has to meet the requirements established by rule. When we get down to the different types of potential people who can apply for these licenses, you will see they usually have to have a license to conduct gambling in Maine. The exception is that any federally recognized Indian tribe in Maine, under all of the bills, can obtain a facility or a mobile operator license. But as far as the temporary license pending the background check, if one of the tribes is applying for a facility license and wants to have a temporary license, they need to have a high stakes BINO facility license to obtain that temporary license. Just based on the discussions of the committee in the 129th legislature, the idea was you could have a temporary license if you're already licensed to do some kind of gaming while pending your evaluation to have this additional sports license. In addition, the temporary license lasts for 1 year or until the decision on the application, whichever is shorter. Once the temporary license expires, you just then have your initial license for the rest of that 2-year term that the initial license lasts. There are also occupational licenses required under all 4 bills, and they're only required for employees of facility operators. So remember, those are the bricks and mortar facilities that offer in-person sports betting. So a person may not be employed by a facility operator in a job that's classified by the director as engaged directly in sports wagering related activities unless that person is licensed. The bills all provide that the licensing process must be as far as possible identical to the casino employee licensing process. Under the sports wagering bills, it's a $250 initial 1-year license fee and a $50 annual renewal fee for that employee license. There is an exception that says an individual who's actively licensed as a casino employee doesn't need to pay a separate fee to also be licensed to work for a facility operator to conduct sports wagering. And then this compare paragraph just explains to you the way that, in a short version, the way that the slot machine and casino operator employees licensing works under current law, because the sports wagering licensing is supposed to be as identical as possible. All 4 bills also require facility and mobile operators to adopt comprehensive house rules that meet minimum standards established by the Gambling Control Unit Director, including that the house rules have to specify the amount paid on winning wagers, the effect of schedule changes, those would be schedule changes for the sports event itself, including information on circumstances for voiding wagers and treatment of any errors, late wagers, or any kind of related issues. The house rules have to not only meet the standards established by the director, but they have to be approved by the director. They have to be advertised and readily available to customers. All 4 bills provide that the following list of individuals may not make a sports wager. That includes an individual who's less than 21 years of age, any athletes, participants, or officials involved in the event subject to the wager, any operator or management services licensee, or an employee of such a licensee, and a person living in their households, although there is an exception. If you're not actually an employee or an operator yourself, you just live in the household, you are allowed to place a sports wager, but you have to do it through a different operator. So you can't use the sports book that is run by or involving the person you live with. Other people who can't make sports wagers include not interesting, although they may be, but interested parties defined by the director by rule. And although they're defined by the director, the bills all provide suggestions that it would include the owners and employees of the teams that are participating in the event, as well as the owners and employees of other teams in the league, and then also of the league itself. Also, anyone who's on a list established by the director, and that list could include both those who voluntarily ask to be prohibited from placing sports wagers, as well as anyone who's placed on the list involuntarily, and the placement on the list involuntarily has to be under standards established by rule. In addition, no one can make a bet on behalf of another, so all bills provide that a third person may not make a wager on behalf of or as the agent or custodian of another person. And finally, if you work for the Gambling Control Unit, you can't place sports wagers. So if you work there, think about it twice. Just kidding.
Yeah, sorry, Milt.
The next thing that all of the bills include are identifying the types of sports events that are subject to wagers. So they all include professional, collegiate, and amateur sports or athletic events, including international events. They all also say Olympic events. I just couldn't fit it on the same line. Motor vehicle races and esports. And as it was sort of made fun of last time, but I still don't really understand what esports are, so you're going to have to ask someone else. There is an exception in all of the bills, so that wagers may not be accepted on a high school event or on any other event where a majority of the participants are under 18 years of age, or on any collegiate level event in which a main team participates. All 4 of the bills provide for child support interception. So an operator has to intercept sports wagering winnings for the payment of past due court-determined child support debt if the winnings exceed the amount for which the licensee is required to file a form with the IRS. My understanding from reading the instructions from those forms is that those forms have to be filed on winnings that are at least $600 and at least 300 times the amount of the wager. That's a pretty cool return. Or winnings that, when you subtract out the wager, are at least $5,000. And then Jerry Joy, the director of the Division of Support Enforcement for the Department of Health and Human Services, did provide testimony kind of explaining that child support interception a little bit more and explaining how it relates to some other gaming laws in Maine law that require child support interception. All 4 of the bills require the director to engage in rulemaking that have to address certain topics. including any additional qualifications for and any procedures for obtaining licenses, including temporary licenses. The rules have to address sports wagering operations, including authorized wagering systems, whether the use of credit and checks is allowed, any required receipts for wagers, requirements for protection of patrons, promotion of social responsibility, and display of resources for problem gambling, which have to be at each facility and on each mobile application or digital platform. The director may, if he or she, if it's at that time a she, deems necessary, establish a maximum per event per person wager. That's not required, that's discretionary. All the rest of the rules are required, however. Has to establish standards for house rules and the procedure for the approval of those rules by the director. Minimum design and security requirements for facility operators. So remember, those are your in-person sports wagering places. That would include security of the premises. If there's going to be self-serve kiosks in those premises, what requirements attend to those? Requirements for confirming the identity and age of anyone placing a wager, and requiring a refund of any wager placed by a prohibited person. If you're a mobile operator, the rules have to include minimum design and security requirements for your mobile applications and digital platforms, including identity, age, and geolocation verification requirements. Geolocation being, remember that only someone located in Maine physically can place a sports wager. So that's the geolocation requirement. And again, requiring a refund if the person who placed the wager is actually a prohibited person. The rules can also include an identification of interested parties prohibited from making wagers. Remember, these might be your league or team owners or employees. There also has to be minimum design, security, testing, and approval requirements for that sports wagering equipment, system, and services that are sold by suppliers that we discussed earlier. Minimum requirements for the contracts between the operators and the management services licensees. Minimum operator and internal control standards and record-keeping requirements, which must include audit requirements and required reporting of wagers and revenues to the director, as well as the establishment of the list of persons who can't participate either because they choose to be placed on the list or they're involuntarily placed, in which case the rules have to address the standards for being placed on that list and how you can be removed from that list. All four bills also provide that these initial sports wagering rules can be adopted through emergency rulemaking. There are some other provisions in the bills as well, including requiring the director to investigate complaints and some due process protections for anyone being investigated. It allows, based on a complaint, certain administrative sanctions, including a written reprimand to the licensee, a condition of probation on the licensee moving forward. The license could be suspended or revoked, or civil penalties of up to $25,000 per violation could be imposed. And that's all through the licensing process. And then also the licensees also have to permit the director or designee unrestricted access to any sports wagering facility, including to any locked area during regular business hours. Finally, the summaries of all four of the bills state that they amend the fantasy sports laws to allow fantasy contests based on the performance of participants in college athletic events. So remember, fantasy competitions are separate. We talked about the rules for those earlier this year. And each of these bills state in the summary that they're going to amend that separate law, but actually LD 1404 doesn't contain that amendment, and I don't know if that's on purpose or just a drafting error. So those are the common provisions. There are some ways that these bills differ that I'm going to summarize next. So this chart, because you can't get away with having a bill analysis without a chart, it's just not possible. My name's on it. Compares Senator Lucchini's bill, Senator Baldacci's bill, Senator Jackson's bill, and Representative Roach's bill in that order. So first of all, as far as the facility sports wagering licenses, these are, remember, your in-person sports wagering. They all include commercial tracks, OTBs of some sort, casinos or slot machine facilities, and then a federally recognized Indian tribe in the state. So all of those entities can apply for a facility sports wagering license. The difference is that Senator Lucchini's bill and Senator Jackson's bill include not only off-track betting facilities that are licensed under statute, which is section 275D of Title 8, but also OTBs that are licensed under a law that was enacted in the 129th legislature, which is the law through which Scarborough Downs got its OTB license. And we're going to talk about that at length for other bills that are before us in work session today. So I can go into that more now, or we can wait and you can just be under suspense and wondering what all that means. There are also mobile sports wagering licenses. As you remember, these are your online or through digital platforms or mobile apps. And all of the entities listed above can obtain a mobile sports wagering license, as well as for Senator Lucchini's bill and for Representative Roach's bill, a qualified gaming entity. And that would be an entity that offers mobile sports wagering under another state's regulatory structure. So it doesn't have to be a main company, but if it's licensed in another state to offer mobile sports wagering, then it could apply for a mobile sports wagering license in May. Senator Baldacci and Senator Jackson don't include that provision in their bills. Now, the tax rates for all of the bills are the same in that a facility operator, so the in-person sports bets, are taxed at a 10% rate. And for a mobile operator, they're taxed at a 16% rate. So all the bills agree on those rates. It's just where they send the money that's different. And what is the tax imposed on? For all of them, it's imposed on the adjusted gross sports wagering receipts. What does that mean? That means you take all the wagers, you add them up, and you subtract out any winnings that were paid out, and you subtract out any federal excise taxes that were paid. That's the adjusted gross sports wagering receipts, and it's 10% tax rate for in-person bets and 16% tax rate for mobile or digital bets. If you're looking at 1352, so Senator Lucchini's bill, he would send 1% of those revenues for facility sports wagering, so in-person bets, 1% to the Gambling Control Unit for its administrative expenses, 1% for gambling prevention, and the rest, 8% to the general fund. Similarly, for mobile sports wagering, he still has 1% to the administrative expenses of the unit, 1% to gambling prevention, and then the 14%, because remember, it's a higher tax rate, to the general fund. Senator Baldacci's bill is very similar, where he has 1% to the Gambling Control Unit, 1% to gambling prevention, whether it's in-person or mobile wagering, and the remainder goes to K-12 education. And I'm going to skip over Senator Jackson's for just a second and say Representative Roach's is the same as Senator Lucchini's bill in that you're going to send it 1% each to the Gambling Control Unit's expenses and gambling prevention, and then the remainder for both in-person and mobile betting, all the remaining revenue would go to the general fund. President Jackson's bill is different. He would send 1/4% to the Gambling Control Unit for its expenses, 1/4% to gambling prevention, 0.55% to the fund to supplement harness racing purses, 0.55% to the Sire Stakes Fund, 0.4% to the Agricultural Fair Promotion Fund, which is created in his bill, and then still 8% to the general fund if it's in person and 14% to the general fund if it's mobile sports wagering. So President Jackson's bill takes a different approach in sending some revenue to the harness racing industry. So 3 of the bills follow the same penalty scheme for unlicensed operation of sports wagering as each other. So under those 3 bills, so these are the ones that aren't Senator Lucchini's bill, the first time you operate sports wagering without a license, you'd be subject to a fine of up to $10,000 and imprisonment up to 90 days. The second time you're found to have violated that by operating sports wagering without a license, you have a $50 fine maximum and a maximum imprisonment term of 6 months. And then any subsequent violation would subject you to a minimum fine of $25,000 with a maximum $100,000 fine and a minimum term of 1 year imprisonment with a maximum of 5 years imprisonment. Senator Lucchini's follows the provisions of current law about unlawful gambling, which are described on the next page. So as far as provisions that are unique to each bill, that aren't like easily shoehorned into a chart, unfortunately for me, although I did throw in a chart just for fun. So for Senator Lucchini's bill, he added to his bill that the director would have to adopt as part of the rulemaking rules that prohibit misleading or false advertisements, and that also prohibit advertisements that are specifically designed to appeal to minors or that have a high likelihood of reaching minors, including by being close to schools. He also, as I mentioned above, would apply the current laws about unlawful gambling, those criminal laws, to any unlicensed sports wagering activity. So if you're a person, and that does not include the person placing a bet, this is only the business, who intentionally or knowingly profits from unlawful gambling activity under current law, you're subject to a $2,000 fine and 1 year imprisonment if you're found guilty. If you're an individual, if you're an organization, we can't throw you in jail, but you could be fined up to $10,000. And you, no matter whether you're individual or an organization, you're subject to forfeiture of all the income that you might have profited from unlawful gambling by gaining. In addition, if you if you accept or receive more than 5 bets that are worth more than $500 within any 24-hour period, that's considered aggravated unlawful gambling under current law, and the penalties are steeper, so up to a $20,000 fine and 10 years of imprisonment if you're an individual. If you're an organization, it'd be a fine of up to $40,000, and again, forfeiture of all income you received from that unlawful gambling activity. As I mentioned earlier, President Jackson's bill, the 1405, has some unique provisions involving harness racing. So his bill establishes the Agricultural Fair Promotion Fund, which is designed to benefit organizations that are identified by the Commissioner of the Department of Agriculture, Conservation, and Forestry as having had for at least 25 years a primary purpose of promoting agricultural fairs in Maine. And if you remember, 0.4% of the adjusted gross force wagering receipts are sent to this fund, whether it's mobile or in-person wagering. In addition, his bill has some clarifying language about the calculation of the disbursements from the supplemental, from the fund to supplement harness racing purses. That if you look at his bill, you can see that it talks about multiplying something by a fraction, but it only has a numerator or a denominator. I can't remember which, so it just clarifies that language. And in addition, Senator Jackson's bill also addresses a topic which we're going to talk about with some of the other work sessions today, which is clarifying what are the rights and responsibilities of an off-track betting facility that wasn't licensed under current law, which is Title 8, Section 275. I think it's D. Instead, if it was licensed under that law that was enacted in the 129th legislature, which is Public Law 2019, Chapter 626, that act provided or allowed for the issuance of a separate off-track betting facility license under certain circumstances. My understanding that one was awarded, and that's to Scarborough Downs. But because of the language of that law, it isn't clear which provisions of current law apply to those OTBs and which don't. So his bill, his sports wagering bill, goes through all of those laws, and it clarifies which of those laws apply to that OTB, and that's all in Part B of his bill. And I felt like I put so many pages on this analysis that I didn't want to restate them here, but the bill analysis to LD 860 lays all of that out for you, and we can go through it whenever you think is appropriate. 1527, which is Representative Roach's bill, has several unique provisions, including a provision about some prohibited types of wagers. So his bill would provide that for events with a sports governing body within the United States, operators, so those are facility, in-person operators and mobile operators, both, may not accept wagers on injuries, penalties, or outcomes of disciplinary or replay rulings for those United States sports governing body events. In addition, under his bill, any sports governing body, so that's even one outside of the United States, may request that the director prohibit certain types, forms, or categories of wagering if it demonstrates good cause to believe that those wagers would be likely to undermine the integrity or perceived integrity of the sporting event or governing body. When receiving that request, the director must consider comments from operators, but on a temporary basis can provisionally grant the request if it's more likely than not that good cause would be shown, according to the director. In addition, there are some provisions in Representative Roach's bill about abnormal wagering activity. So operators must report activity that raises concerns about the integrity of the sporting event or potential match fixing to the director and to the relevant sports governing body. The operators have to use commercially reasonable efforts to cooperate with any information requests from law enforcement and sports governing body related to abnormal wagering activity. The information that is shared with the director by sports governing bodies for the purposes of investigating this abnormal wagering activity has to be kept confidential by the director unless disclosure is required by the director, directed by law, or the sports governing body consents to releasing that information. In addition, information shared with the sports governing body by the operators specifically may not be used for commercial purposes and may not be disclosed further except during the conduct of and resolution of any integrity related investigations by that governing body, as well as the sports governing body is allowed under Representative Roach's bill to disclose this information that operators gave it to the public if it's necessary to preserve the actual or perceived integrity of its sports events. But first, the sports governing body would have to provide notice to the operator and give the operator an opportunity to object to the disclosure. There are also provisions about official league data in Representative Roach's bill. So operators would not be required to use official league data for what are termed tier 1 wagers in that bill, which are wagers on the final outcome of an event if the wager is placed before the event begins. But for all other wagers, which are considered tier 2 wagers, the U.S. sports governing body can notify the director that it wants to require sports wagering operators to use official league data for those wagers. And that's only allowed, the requirement's only allowed if the sports governing body is able to provide a feed of that data to the operators, and it is able to do so on a commercially reasonable terms. So whatever the price is has to be commercially reasonable. Under Representative Roach's bill, operators can request a determination from the director that the terms and conditions for obtaining that data are commercially unreasonable. And there are a whole host of factors listed in the bill on page 17. And during the pendency of the determination, which cannot take longer than 60 days, while the operators have objected to the terms by which they're required to purchase the data, during that time, they don't have to use the official leak data. They have to wait until the outcome. In addition, the sports governing body is not required to obtain a license to enter into an agreement with the operators to share in the profits of sports wagering placed on the sports events conducted by that body. So I presume that that provision is in there because maybe the commercially reasonable terms for getting the official league data is that you share some of your sports wagering profits with us. And I think this provision of the bill is designed to say, well, that doesn't make you an operator that needs to get a license. You can just enter into that contract and it's fine. There are also some specific statutory record keeping requirements in Representative Roach's bill. So if you remember, all of the bills require the director to impose some record keeping requirements by rule. But this bill also additionally would say in statute that operators have to maintain itemized records of all wagers placed in abnormal wagering activity for 3 years. And they'd have to maintain video recordings of in-person wagers for at least 1 year. They'd have to make those records available to the director upon request or as required by court order. Operators would also have to maintain anonymized but itemized wagering information in real time and disclose this information to the director upon request or to the relevant sports governing body if it's using that for integrity monitoring purposes and it's told the director that's going to use the data for that purpose. Okay, so that's what the contents are of the bills. Just a reminder, because it was asked, that in the 129th legislature, this committee considered 6 different bills related to sports betting and combined selected provisions from each of those bills into what was then a concept draft, LD 553. And the committee voted 9-3 on that concept draft, with 1 person voting against sports wagering entirely. The majority report, I was asked to tell you what it compared to. So it was substantively the same as Senator Lucchini's bill, LD 1352, with a few exceptions. So the majority report to LD 553 did impose the unlicensed conduct penalties that are described for all of the other bills above, those first offense, second offense, and then subsequent offense penalties. It didn't use current law unlawful gambling penalties. And also the other difference is it didn't require the restriction of advertising to minors. The minority report was identical to the majority report, except that it required tethering in that it did not allow a qualifying gaming entity to obtain its own license to conduct mobile sports wagering. The legislature did accept the majority report to LD 553, and it was passed to be enacted, but the governor vetoed it, and that veto was sustained. There's a request for the veto letter, and it is attached right to this bill analysis. As far as relevant federal laws, the upshot of them is that the state is not allowed to allow sports wagering enterprises to accept bets placed by people who are not physically located in Maine if those bets are placed over the internet. So where do we come up with that prohibition? Well, the Interstate Wire Act of 1961. In 1961, they were thinking about mobile sports betting. I bet you didn't realize. But when they passed that law, they said that they prohibit the use of a wire communication facility for the transmission in interstate commerce of bets or wagers or information assisting in the placing of bets or wagers on any sporting event. And a wire communication is defined in a way that has been interpreted by the Department of Justice to include the internet or mobile applications. So what does that mean? You can't transmit a bet over the internet in interstate commerce on a sports event. So if you want to bet on the internet on a sports event, you need to be located in the state where you're placing, where the operator is located that you're placing the bet. Violations by persons of the Interstate Wire Act are punishable by up to 2 years imprisonment and a fine of up to twice the gain to the defendant. And violations are violations by the business entity offering the wagering. It's not a violation by the person who places the bet themselves. There's also the Unlawful Internet Gambling Enforcement Act of 2006, which basically says if a wager placed over the internet violates state law or federal law, then it also violates the Unlawful Internet Gambling Enforcement Act. So since interstate sports wagers over the internet violate the Interstate Wire Act of 1961, they also violate this federal law. And it has similar penalties for people who are businesses engaging in sports wagering over the internet that allow interstate bets, except that the penalty is 5 years imprisonment instead of 2, or up to 5 years. Okay, so it's my understanding from the way that the public hearing went that the biggest issue, or one of the big issues, is whether to require tethering. And I just wanted to raise to you the possibility of a Dormant Commerce Clause challenge. I can't guarantee one would even be brought, or if it would be brought, how a court would determine it. But I did want to give you some background. So Article 1, Section 8 of the U.S. Constitution grants Congress the authority to regulate commerce among the several states. So that's how Congress gets to enact all of its laws about interstate commerce. But the U.S. Supreme Court has repeatedly explained when it interprets the Commerce Clause that it also prohibits economic protectionism, that is, regulatory measures designed to benefit in-state economic interests by burdening out-of-state competitors. Thus, state statutes that clearly discriminate against interstate commerce are routinely struck down unless the discrimination is demonstrably justified by a valid factor unrelated to economic protectionism. And that is a quote from the US Supreme Court. A good example that makes sense to go over in this committee is Granholm versus Heald. In that case, the Supreme Court invalidated 2 states' laws that authorized in-state wineries, but not out-of-state wineries, to ship their products directly to consumers. This may sound familiar to you. The court held that the states failed to show that their laws advanced a legitimate local purpose that could not be adequately served by a reasonable, non-discriminatory alternative. Now, the states did try to say that we have a really good reason for only allowing our in-state wineries to ship to consumers and not allowing out-of-state wineries. And the reasons that were set forth and the court's analysis of them, I think, is helpful for you to understand. So the states had argued that restricting direct wine shipments was necessary to avoid increasing alcohol consumption by minors, who the states noted had easy access to credit cards and the internet and might then take advantage of direct shipments to purchase wine illegally. In a somewhat funny thing, the Supreme Court said that There was no concrete evidence that direct shipping of wine was likely to increase minors' alcohol consumption, and they noted, after all, that minors prefer beer and hard liquor, which is good to know. They also noted that even if internet sales had been shown by the states to increase the risk of underage drinking, there was no proof that fact would not justify regulations limiting only out-of-state direct shipments. Instead, they said that the states could impose uniform requirements for an adult signature upon delivery, for example, and there already were stringent penalties to deter noncompliance by both in-state and out-of-state wineries because they could lose their federal and state licenses if they were making sales to minors. So the court said there was no reason to pick on only out-of-state direct shipments and say those were prohibited if it was okay to allow in-state direct shipments. In addition, the court rejected the state's other arguments that the laws were necessary to protect public safety and to provide regulatory accountability. And the court noted, quote, improvements in technology have eased the burden of monitoring out-of-state wineries. Background checks can be done electronically. Financial records and sales data can be mailed, faxed, or submitted via email. So in that case, the protection of minors and the need to really investigate which wineries were making these direct shipments, the court was not persuaded that those were legitimate reasons for discriminating against out-of-state entities. It does not mean that they would find that way similarly in gambling. I just wanted you to know that that is an example of the type of hoops that a state is going to have to jump through to show that a law that treats in-state and out-of-state entities differently, that it is justified. So,
sorry. I
just wanted to finish that little piece.
Okay. Yep.
Is that okay?
Yeah, go for it.
Accordingly, if the tethering requirement in either 1404 or 1405 is enacted and subsequently challenged, and I can't guarantee you it even would be challenged, but if it were challenged under the Dormant Commerce Clause, a court is first going to examine whether requiring a mobile operator to contract with a licensed physical gambling facility discriminates against out-of-state commerce. If the court concludes that the provision does discriminate against out-of-state entities, then the state, that's Maine, will be required to demonstrate with concrete evidence that mandatory tethering serves a legitimate state interest that's not related to economic protectionism and that could not be accomplished by a non-discriminatory means. Okay, after that long mouthful, I'm happy to see the question.
Great. I think Representative Wood had a question, and then Representative Supika and Chiazzo.
I'm not sure if I was up first, but thank you, Mr. Chair. I think that tethering and whatever it is, tethering and untethered is one of the, for me, most confusing things. And so I just wondered if we could spend a little bit more time on this paragraph. And I didn't know if I've already missed it or if you were gonna, Janet, talk about tethered and untethered a little bit more.
Let me see if I can explain it a little bit better. And maybe I didn't explain it very well in that. I'm glad you asked. So if you look, I'm just going to compare these first two bills because it's really comparing all of them. They all do similar things. So if you want an in-person sports wagering license, all of the bills, because they're in-person wagering, require you to have an in-person facility of some kind or to be an in-person entity, which makes kind of sense. You need to have a commercial track, be a licensed off-track betting facility, be a casino or slot machine facility, or be a federally recognized Indian tribe in the state. So you're something in state to accept an in-state, in-person sports wagering. Now, the difference between tethering, which is going to be Baldacci's bill for this example, and untethering, which is going to be Senator Lucchini's bill for this example, is that if you're operating under the rubric of Senator Baldacci's bill and you want to offer mobile sports wagering, you need to have a physical in-state presence. You need to be a commercial track, a licensed OTB, a casino or slot facility, or be a federally recognized Indian tribe in the state. Then you can apply to have a mobile sports wagering license. If you do that, you can then contract with an out-of-state company to actually do all of the sports wagering online. So that's the idea of tethering. If you're the out-of-state company and you want to offer mobile sports betting, you need to be tethered to one of these facilities to offer mobile sports wagering in the state. Senator Lucchini's,
excuse me. So the tethering is I'm sorry.
Yep.
So the tethering has to do with the line on your chart about mobile sports
Correct.
wagering.
Correct.
Okay. I think I've got it, but continue.
Yeah, so under Senator Lucchini's bill and Representative Roach's bill, by contrast, any one of these physical or in-state entities can have a mobile sports wagering license, and they can, in fact, contract with an out-of-state provider if they want to, or they can offer their own apps and digital platforms. Or a qualified gaming entity, which is an out-of-state entity or an entity basically that's licensed in another state to provide mobile sports wagering, they can apply directly for a mobile sports wagering license in Maine if you follow 1352 or 1527. And so they're not required to be tethered. They don't have to enter into a contract with an in-state entity to provide that service. They can just do it themselves directly by getting the license.
Right. So I think, so Representative Wood, kind of how, I guess under my bill as well as Representative Roach, we allow for online companies because there's a lot of online sports betting companies. So we just set up a license structure where they apply with the Gambling Control Board and then they can operate in the state of Maine under a license. With the tethered bills, those online providers can't operate in the state of Maine unless they make a deal with one of those brick and mortar facilities.
Okay.
So that's kind of the difference, but that is like going to be one of the key issues, obviously, from the.
Thank you. That was helpful. I just didn't see the word tethered or untethered on the chart, so then I.
Good point.
Exactly. I don't think it's in the law either. So.
Okay.
It's like the shorthand term for it, but
it's just the way people described it.
Yeah, it is very confusing.
Mr. Chair, if I could just explain, maybe another way to explain this as well is the facility sports wagering eligibility, those lists of those physical locations, you would have to drive there, walk in, go up to a window and place your wager. Mobile is once you've created an account, you can do it from your phone in your living room and you don't have to go to a physical location. So I will tell you that probably 85% of the wagers done in the US right now are done by mobile. So obviously I would say we would need to have that mobile element, but that's kind of a separation as well. So a casino could have a walk-in location, a sports book facility, but once you go in and you register, then they would also have the ability through a mobile application to allow that person to then go home and make a wager from their couch.
Thanks, Director. Representative Wood, do you have a follow-up? Yep.
Yes, thank you, Mr. Chair. Director Champion, so in what you described, that's tethered or untethered is the fact that 85% of betting is done online at home or on your phone.
Yeah, basically, if you're tethered, in order to have a mobile application, it would have to be in conjunction with one of those four locations, those four physical locations. But as Senator Lucchini indicated, he also has in his bill and in 1527 that you don't necessarily have to be associated with those physical locations, that you can have a mobile application separate from that. So you either attach it to it or you don't.
But all four bills, in fact, allow for mobile wagering.
Right.
Yep.
Yes. Yes.
Yeah.
You can start out, all four, like 1 through 4, same as above. That's basically saying that all four, you have to have one of those locations in order to either have a physical on-location sports book, and you can also have a mobile application as well. If you're not then the two bills, if you're not associated with those locations, they've authorized you to have the app to do it mobily.
Okay, thank you.
Okay, Representative Supika.
Thank you. I wanted to kind of look at or go back to when you were talking about the Supreme Court and them weighing in. on alcohol and wine sales. Has the Supreme Court weighed in on tethering when it comes to betting?
No.
And do other states have tethering?
So there is a chart
Yeah.
that I showed you that our researchers put together of other states' laws.
Yeah.
And I believe their summary said there were 7 states that may be allowed untethering. I know for sure 2 that were recently enacted did. I found that a news article about it, and they went and found the laws. One was buried in a budget bill in New York. So I thank them for finding that. I will say that I'm just telling you what the analysis is. The fact that some states require tethering does not mean that their laws violate the Dormant Commerce Clause. First of all, they might not have been challenged. And second of all, they might have a reason that they require tethering. So although it's not necessarily listed in that chart, if you look in other sources or if you look at the statutes themselves, there are some states, for example, that say because of public safety, we want to require you to physically go to a location to sign up for a mobile sports wagering account. So because of that, they then say that's why we're tethering our mobile licenses to a physical location, because we're not letting anyone that online, unless they go in person, present themselves, show us that they're over 21 and that they're not somebody who should be prohibited. And so I don't know if that requirement itself and that concern itself would be sufficient for those laws to withstand a Dormant Commerce Clause challenge. I'm not aware of a challenge brought against those, but that's the kind of thing you would need to assert an interest that isn't the type of interest we kept hearing during the hearing, which is these are companies we need to support because they're in-state companies that we like. That's the exact type of interest that the Supreme Court said is not okay.
Oh, gotcha. And then somebody made a statement to me saying that no other state has it untethered. Like I'm now thinking that's not completely true, that there are states that have it untethered.
They may, okay, so there's a couple of ways you could be untethered. Mm-hmm. So when the people said, what I heard at the hearing was that no state had untethered, what I heard was operating now, any state that has gambling facilities is requiring mobile sports wagering to be tied to those facilities. So there are some states, I think Tennessee was the example given. I've never really been to Tennessee other than drive through it, so I can't confirm it. But the idea was they don't have gambling facilities, so they're not tethering sports wagering to a gambling facility that doesn't exist. So that is operational now. There are at least 2 states that very recently enacted laws. One is New York. I'm forgetting off the top of my head the other one, but I have a news article in one of these folders here, and I can look it up while you're caucusing if you want. And they very recently enacted, so they're not yet operational, laws that would allow a certain number of mobile sports licenses that they don't require the applicants to have an in-state facility. So they may not be operating yet, but they are going to allow non-tethered mobile sports wagering. So it may in fact be true that nobody right now allows non-tethering if they have in-person facilities. I'm not sure, I didn't cross-check every state, but it's because of perhaps new laws being passed that are going to in the future allow it, or the state doesn't have in-person gaming facilities.
And a follow-up, Mr. Chair?
Yep.
And then what you just said there, I just wanted to clarify, and it sounded like you said that it might have a certain number that are allowed to be untethered. Did I hear that correctly? Or that could be the case, like they have it regulated where X amount is untethered?
Let me see, maybe I misspoke. So the one I'm most familiar with is New York.
Sorry.
And if there's an article that I can read that can tell me that, I'm happy to just look at that.
Oh, it wasn't a very helpful article. It just gave me a line. I'll be honest.
We can also bring in some.
Maryland, I think, was the one. So Maryland said they're going to allow up to 60 online licenses, and they didn't say that you had to be a physical location to apply.
Okay.
Yeah. And as we dig more into that, we can bring in Mr. Silver and Director Champion just to get into more of the specifics too from the industry, because I know they follow everything across the country on what's going on, and we can certainly bring them in after we get through the analysis to kind of break down a lot of that, because there is a significant amount of conflicting information that we're being given throughout this process. Representative Chiazzo and then Representative McCrate.
Thank you, Mr. Chair. A couple of questions. The first one, Janet, in regards to the dormant commerce clause. Will your concerns stem around the way the bill is written now, or the comments that were received in public hearing?
So I don't know if I would have independently thought of it, except in the 129th, this was vigorously debated, so it was raised. And at the time, there was vigorous debate about the marijuana legislation and the residency requirement. So dormant commerce clause was big in my mind then. Mm-hmm. And so that issue has been raised before, and it persists today in the two different approaches in the bills before you. So I don't know if I would have spotted the issue on my own. I hope I would have. I did reach out to the Attorney General's office and say, am I crazy to think this is an issue? They said no, they can't guarantee how a court would come out. They thought the Granholm case was a great example because of the types of justifications that were given, which might be similar to types of justifications that might be given in a gambling environment. And remember, Granholm involves liquor, and liquor is an area where states have the ability beyond any other business to have control under the 21st Amendment. So if these regulations didn't pass muster under liquor laws, it's hard to believe they would under gambling laws if these are the types of justifications that are going to be given, and if there's no evidence beyond the type of evidence shown in Granholm. It does not mean that you can't require tethering and that it can't be upheld by a court. You just have to have a reason that's asserted and hopefully evidence to back it up by the time it went to court, if it did go to court, to say this is why we need to tether. And that's why I suggested maybe in the other states that do require tethering, the fact that they're saying, look, we're so concerned about underage or the wrong people betting that we're requiring you to physically go show yourself in the facility to register for an account. Maybe that's the justification they have. And that has nothing to do with whether you're an in-state or an out-of-state entity. That has to do with the identity of the wagerer. That's separate. Maybe that's sufficient. I don't know. I'm not a court, so I couldn't tell you.
Yeah. And this was debated at length last session, particularly for those who are here with Representative Cooper. I think she was actually interested in getting an Attorney General's opinion on whether or not this violated, but I don't think we ever went quite to that level. Did you have a follow-up, Representative Chiazzo?
Yeah, I've got a couple actually, and that's fine. I'm okay with that assessment. I guess the question is do we need to put that intent in the bill to prevent the challenge from coming, or is the wording in the bill, in a bill, I shouldn't say the bill because we're talking about multiple bills. Do we need to adjust the wording in a bill to specifically state the intent to avoid that court challenge up front, or is the language that's written now unamended adequate to state an intent?
So usually there's a couple questions in there. Usually the revisor's office does not like intent clauses, but this is the precise type of example where they will approve of one, where you suspect there might be a challenge, usually on constitutional grounds, and the legislature might want to make some findings and reasonings and justifications for what it has done. I don't think that's required, but it can be helpful. It wouldn't prevent somebody from being a court case just because you wrote those intents down. I would like you to know that. But it might make them more hesitant if they think, wow, that's going to be really hard for us to argue against. So that could be helpful. When you go into court, however, I don't know, this might be something the Attorney General's office could tell you better because I don't litigate. But I don't know if you're bound to only follow the reasons that are stated in that intent clause, or if you can have separate justifications that you can come up with later once you get to court. So that might be, if you're interested in that approach, something to explore if you want to go down the path of an intent clause.
Okay. Follow up, Mr. Chair, if I could, please.
Yep.
And then, so you mentioned the states that have facilities, existing brick and mortar gambling facilities, are the ones that are tethered, have tethering.
That's what people said at the hearing. I
Okay,
haven't read through and studied that chart from the researchers. I just got it late yesterday evening or afternoon. I did know about the 2 states that recently passed laws, New York and Maryland, that don't necessarily require tethering. They're not in operation yet, and there may be others. But that's what the people at the hearing said, that all states.
My question is,
just if I can, so I'll just say, when we get to industry specific things, we can do it after the analysis and ask people from the industry who may have those answers more than our analyst would have the answers on those things.
I understood, Mr. Chair, but I actually haven't asked my question yet. So
sorry.
My question was, do tribal gambling facilities count in every state as a registered brick and mortar for the state, or are they considered separate entities?
I don't know how each state treats them, but there are some states that specifically provide for tribal sports wagering, and some that don't. Do remember that sports wagering is class 3 gaming. So if IGRA applies, then there can be a compact negotiated between the tribe and the state to conduct sports wagering. So, I mean, the other states are different because they don't have the Settlement Act and all of that as well.
Yeah, and I only asked that in reference because we're considering bringing that in as well, and I'm trying to see how that would all intertwine.
I don't know how the industry people who might object, although the testimony was that they don't object, but who might object to tethering. I don't know how they view the tribes in that, whether they consider that tethering or not. You'd have to ask them.
Okay. And then if I could, Mr. Chair, last question for Director Champy.
Sure, yeah, and then, yep.
Yeah, it's just a follow-up, sir, to your comment. I just want to be sure I clearly understand. Tethering or untethering, regardless, it doesn't matter how it's done. Even tethered, people can still vote a bet from their home. They would just have to go through would it be a skin or a website that would be hosted by the brick and mortar facility?
Yeah, that's correct.
Okay.
Yes.
Okay, thank you.
Yes, and the only other comment I would make on the tethering is right now you have fantasy contests, legal fantasy contests in Maine, and that application is not tethered. We don't have people sending people to physical locations to do fantasy contests in Maine. Right now, you can do it online. Just as an example of what we currently allow in Maine.
Thank you, Director. Are you all set, Chairman? Yeah. Representative McCrate. Yeah, Representative McCrate, and then Representative Corey.
Thank you, Mr. Chair. Of the many things I'm confused about, this may be for Director Champion. The geolocation I'm thinking about. You need to be in the state to place a bet. So does that mean that if facility or untethered has a mobile app, as long as it's licensed in the state, they don't have to be located in the state? Is that right?
Yeah, they don't have to be located. And basically what happens is once you establish or you make that wager either with your mobile phone or your laptop or anything like that, it basically has to communicate and identify that you're actually in the state.
But the licensed entity doesn't have to be in the state, the mobile operator.
Yeah, the way it's the qualified mobile operators do not have to be. In fact, I think one of the qualifications in one of the bills is that they have to be established in another jurisdiction.
Representative Corey. Sorry, it's hard to see everybody on this view.
Thank you, Mr. Chair. After listening to that last discussion sort of about tethered versus untethered and, the idea of sort of intent and, the idea of how, some of these bills were presented as this being kind of a business, do you know what I mean, concern more so than, a concern, with regard to underage gambling or anything like that, and the need for a physical location. It would feel personally a little weird for me to stuff that toothpaste, do you know what I mean, back into the tube and say, okay, I have to go tethered now, in order to do this, when I know that the reason why this has been pitched, do you know what I mean? And I really have, I feel like, when people look at like what our intent is, they're also looking at not what we actually wrote into the law, but necessarily the testimony we received and what motivated us to do something. So I'm very uncomfortable creating kind of an intent piece to say that, oh no, what we really want is this. I'm not going to go there. So, thank you. That's all I have to say.
No, and I agree. I mean, the amount of written testimony that we received, particularly from some parts of the industry, are just blatantly economic protectionism. And that's when you run into trouble. So, I mean, but who knows how it would end up turning out. But that's the only argument that I heard. So
courts disagree on whether they look at testimony or whether they look at statements, on the floor or something like that. And that would be why putting it right in the statute is maybe this is our official statement of why. So.
Yeah, I think probably at this point, if we can just continue through the analysis, and then, I mean, we're going to have a much deeper dive on all elements of this as we go forward. So, and we can do that today. And certainly as we work through this, if people think of, if you want to call up people from the industry and everything else after the analysis, and then we can ask them questions, we certainly want to give everybody the opportunity to do that. So.
And then, as I mentioned, there is the other states chart that was prepared and is available on the electronic LD file, and I did email it to you all. So during the hearing, there were some issues and amendments raised and proposed during the testimony. So the Maine Association of Agricultural Fairs, State Harness Racing Commission, Maine Harness Horsemen's Association, and Maine Standardbred Breeders and Owners Association, I really sincerely hope I got all of those right, and if I didn't, my apologies. They all testified in favor of mitigating the potential impact on the harness racing industry by tethering mobile sports wagering to casinos, OTBs, and commercial tracks, which they pointed out are locations that introduce customers to the harness racing industry, and by directing a percentage of sports wagering tax revenue to agricultural fairs and the harness racing industry. In addition, Penn National Gaming proposed reducing the tax rates to 7.5% on in-person wagers and 10% on mobile sports wagers, the revenues from them, and not to mandate the use of official league data in statutes. DraftKings, FanDuel, and BetMGM submitted testimony requesting clarification that although sports wagers may not be placed on any single game or match in which a Maine collegiate team participates, they wanted some clarification that betting would be authorized on other games or matches in a tournament, even though a Maine collegiate team might be part of that tournament. So if it's like the Final Four and Maine is in one semifinal, that there could be sports wagering in Maine on the other semifinal that Maine's not part of, even though it's in the tournament. The National Football League didn't propose amending any single bill, but did list several issues that it thought should be addressed, including prohibiting sports wagering by folks with insider information. That's part of all the bills right now. Requiring operators to enforce the prohibition on wagers by persons under 21 years of age. I think that's in all the bills now, but I don't know if they'd want more. Prohibit wagers on in-match events that are more likely to be subject to match fixing. Requiring the use of official league data to determine the outcome of wagers. Requiring maintenance of detailed records in a location within the state for at least 5 years. Requiring operators to share real-time information on disciplinary proceedings against the operator on abnormal sports wagering activity or on other suspicious wagering with leagues, and then providing resources for compulsive gambling treatment and addiction, and then ensuring a competitive mobile market to compete with illegal offshore operators. The National Council on Problem Gambling also didn't say amend bill X, Y, or Z in different ways, but they did suggest some issues for the committee to consider, including dedicating a portion of sports wagering revenue to preventing and treating gambling addiction, surveying gambling addiction prevalence before and during implementation to monitor the impact of sports wagering, to fund and promote a helpline to address problem gambling, and requiring operators to provide for customer self-exclusion and setting limits on time and money spent betting, with information on these programs contained in all external marketing. So for that last thing, I think that would be in addition to the statewide list. They were proposing each operator have a list and allow people to say, don't let me bet more than $100 a day. And then that limitation would be in place. There are some technical issues, as I mentioned before. All four of the bills, if you read the summaries, do adjust the fantasy sports law to say that fantasy contest operators can offer contests based on the performance of participants in collegiate athletic events, but the actual text of LD 1404 doesn't actually contain that provision. So if you wanted to move forward that and you wanted to add it back, we could, or if you liked that it wasn't there, that's fine. Just wanted you to know it's not actually in the text, even though it's in the summary. LD 1405, it, as I mentioned, is President Jackson's bill. Just a reminder, that's the one that includes all the provisions about the off-track betting facilities that were licensed under that separate public law from the 129th legislature, rather than being licensed through the established process and statute. And it amends, when it goes through all of the provisions in Part B to talk about those off-track betting facilities, it amends the law to provide that an OTB licensed under that separate public law is allowed to receive a share of revenues generated by the tax on advanced deposit wagering commissions for wagers placed on horse races conducted in the state. But there's another provision about wagers on horse races conducted on out-of-state races, and that is not also amended, and I'm not sure if that's just an oversight or an error, if both of those provisions were intended to be amended or not. All of the bills before you contain some confidentiality provisions, specifically or regarding the information results of fingerprint-based background checks, and then the child support interception information. LD 1527 also requires the director to keep certain information confidential if it's provided by a sports governing body. So all of those provisions would be exceptions to the public records requirements in the Freedom of Access Act. So if a majority of this committee votes in favor of any of those provisions, you would have to go before the Judiciary Committee for a separate special review focusing on the Freedom of Access Act. So if we move forward, I'll probably just ask you to designate someone to come with me. I'll write a memo to the Judiciary Committee and we'll go see what they think about those provisions. In addition,
can I interrupt you for a second? Sorry.
Oh, sure. Sorry.
We have a question from Representative Chiazzo.
Thank you, Mr. Chair. Sorry, Janet. When you were talking about the PL 219 for classification of OTBs,
yeah.
and in your chart, you, LD 1352 also says any OTB. So would that include?
Right. So LD 1352 and then LD 1405 say any OTB, and that includes the 2019 Chapter 626 OTB. So Scarborough Downs, just to be like upfront about it. Both of those bills allow them to obtain facility and mobile sports wagering licenses, but Senator Jackson's bill goes further, and it actually defines all of the rights and responsibilities of that particular OTB. That is not part of Senator Lucchini's bill. His bill just talks about them being able to get a sports wagering license, but doesn't talk about anything else about them.
Okay, understood. Thank you.
And then as far as three of the bills contain specific penalty provisions for unlicensed sports wagering operations. So under Joint Rule 319, if a majority of the committee votes in favor of that legislation, because it enacts a new crime, it would be subject to review by the Criminal Justice Committee. So again, that would involve writing a memo. Lucky me, I get to write the memo, going to the Criminal Justice Committee, and then seeing how they feel that the bills would impact the criminal justice system. As I read LD 1352, it doesn't enact a new crime. It just provides that the existing crime applies to this new conduct. I don't believe that requires a criminal justice review, but I can confirm that internally if you vote for something like LD 1352, or at least that provision of it. I think that might not require criminal justice review. And then just a reminder that LD 554, if you enact it, would render all state gambling laws, including laws governing sports betting, if they're enacted, it would render them all inapplicable to the conduct of gaming by the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians. Instead, the Indian Gaming Regulatory Act would apply to those tribes' conduct of sports betting, which is considered Class 3 gaming under the Indian Gaming Regulatory Act, and thus it would require negotiation of a tribal state compact governing sports wagering, or it could be just a tribal state compact governing all Class 3 gaming and includes sports wagering. The LD 554 does not involve anything about the gaming activities of the heuristic band of Micmacs, however, so to the extent you're talking about the heuristic band of Micmacs, none of the bills conflict with LD 554 to the extent they allow mobile sports wagering or facility sports wagering licenses to that tribe. And then we don't have fiscal information yet, but you can have some kind of a rough comparison by looking at the fiscal notes, the majority and the minority reports of LD 553. I will say that the fiscal notes, when I looked at them, looked identical, at least as I reminded myself of them. So I don't think the tethering had any impact on the fiscal notes, but there are some fiscal impacts of sports wagering legislation.
Okay, Representative McCray.
Thank you, Mr. Chair. Janet, could you go back to the 554?
Sure.
I don't understand. If that passes, what happens?
So I'm going to go back up here to show you the chart. So who can get licenses under all of these bills? So either for a facility that's in-person sports wagering, or for a mobile, that's obviously mobile sports wagering. All of those, or those two types of licenses under all of the bills, are available to a federally recognized Indian tribe in the state. But that won't matter if LD 554 is passed, because they're not going to be governed. 3 of the tribes are not going to be governed by whether or not the sports wagering law allows them to get a license or not. It's not going to matter, because under 554, IGRA would apply instead. And that would govern whether or not they can conduct sports wagering and the negotiation of a compact, et cetera, and so forth. The only difference being that for the heuristic band of Micmacs, you might want to keep that provision if you want them to be able to conduct sports wagering, and you don't want them to be left out because they're not part of LD 554. If that's sort of your approach, then it might be worth keeping this provision in. Plus, you don't know how 554 will be decided. So I just wanted you to know that they're kind of different paths. You know, if 554 passes, then it's not going to matter whether you decide to let them or not let them in the sports wagering bill. They're going to be allowed to under IGRA, and they're going to go down the compact route.
Okay. Follow up, Mr. Chair?
Yep.
So it's not a problem if it occurs, if one of the sports wagering bills passes with the federally recognized Indian tribe in.
I don't think so. It would cover the heuristic band of Micmacs, and it would sort of be a backup. Remember, there were some concerns whether the state can apply IGRA to Maine without congressional action. Right. Some people say you can, some people say you can't. So it's kind of like a fallback position.
Okay, great, thank you.
Great, thank you, Janet. And on the last page, was that just the last couple of pages, that was the veto letter, it looks like?
Yes, and this shows you what the governor's concerns were.
Okay.
I can go through it if you want, but I think you can all read it if you want to, either way.
Yeah, I think it's there. Yeah, people can read through it. Awesome, thank you for that, Janet. That's a really great overview of all of these bills. They're obviously, there's a lot to unpack in each of these, but I do want to bring in Mr. Silver from the Gambling Control Board as well, who may be able to help with some of the questions that were asked earlier. And also, I mean, you know, like I kind of said at the outset, I know I mean, I wouldn't expect anybody where this is new to be prepared to vote or anything today, but if you want to ask questions of people, I think this is a good time just to get the conversation started. We can do work sessions as we see fit on this topic. And if there's people from industry or anything, we can kind of go in phases if you want to hear from them as well on their any questions of them as we go through. So Mr. Silver, I saw you had your hand up. Did you want to add something to the conversation? Was it related to tethering?
Thank you. Yeah, I was just going to try to jump in and help explain, but I think everyone did a pretty good job of that, and also touch upon, I hear people keep referring to out of state and in state, and that's, at least from a legal perspective, not, it's a misnomer, right? Because you've got to have the person placing the wager has to be in state, the servers accepting that wager need to be in state, and some online operators may actually be in-state companies or new companies that launch in the state of Maine. So just correcting that language.
Sure. I have a question on the taxation. I don't know if you've dug into the weeds this far on this, but if we were in a tethering model and you have this online provider tethered to a casino in the state of Maine, that fee that they pay, the market access fee, how is that taxed? Is that taxed as though it was an online bet from the online company, or if it's part of a tethering agreement? Do you know how the revenues from the tethering agreement are typically taxed? I mean, I don't know if they'd be considered gaming revenue for the casino, or if it would be just other revenue that would be taxed at just a corporate tax rate.
You're asking if say an online operator pays a fee to a brick and mortar for the partnership fee?
Yeah.
I don't know the answer to that. And in some situations, I'll say there may not be a flat fee. It may be in terms of a revenue share. So, there may not be an upfront flat amount of money exchange. It's just for the privilege of having a license and being partnered with you, we're gonna pay X percent of revenue.
Right. And I mean, I just from reading about this is one of the benefits of tethering from the casino perspective that you can control the content that's on the app. And so you can provide incentives for somebody like a $20 slot play or something to bring them into the casino. I mean, is that to a certain extent something that's used with tethering across the country?
Well, I think that could happen whether it's tethered or untethered, right? Depending upon what your brand is. And I assume the same would be for other brick and mortar. I mean, you look at a state like Maryland, where bars and restaurants are going to have licenses. So, you might have one that's offering you some, beer discounts to come in and do that. Or in a number of states, Arizona just passed, the stadiums and the arenas are going to have sports books, maybe even a golf course or two. So that exists, whether it's tethered or untethered. I think as at the end of the day, it's just a matter of, these are, the argument as I understand it is, these are facilities that exist, they're licensed, the state presumably trusts them, and certainly at the board we do, to operate, gaming legally and safely in a regulated environment. So they have the expertise to do that. When you talk about the OTBs, same type of argument. I think it becomes more about, do you want to, help protect that industry as a policy choice? Legally, they're all going to be able to offer the same types of products. It's just a matter of, do you require online operators to go through that extra step?
And the new model, or I guess the model you said in Maryland, where they're having, looking beyond just one industry and doing restaurants and things. Do you know if that's a tethered model or if that's an untethered?
Well, it's kind of a combination of both, in that, if you have a certain class of liquor license, you're gonna be qualified for for a sports betting license. But I believe, and I didn't look most recently, there's provisions that are unique there about a certain percentage of minority owned businesses would be qualified for a license. So it's a lot broader and more complicated.
Right. And yeah, so I'm more just curious if an online provider can come in and operate without being tied. I don't know what it is. I can look it up too. It's hard to keep track of each state because it's kind of different all over the place.
Yes, but yeah, I mean, yes. I mean, there's what I think 60 licenses max. So it's a lot different beast.
Yeah, in a small state too. All right, Director Champion, did you want to add to that?
Yeah, I think it really just it boils down to the only thing that we've really established in the last few years is that you have to have the mobile element. Whether or not you want to have people go in and physically register or not, again, you're not requiring that with fantasy contests right now, Maine. So that's that's the only thing that I would kind of like add to it. But
thanks.
Well, and also you can tether, right? You can go the tethering route without requiring in-person registration. And in fact, the one piece of advocacy I'd put forth is to not do that. We saw what happened in Rhode Island. I mean, Rhode Island is like the cautionary tale for the rest of the country of, you didn't have mobile, then you had in-person registrations. It's an unnecessary step. So you can tether, right? You can go the tethering route without requiring those in-person steps.
Right. Representative Chiazzo.
Thank you, Mr. Chair. A couple questions. If I heard you correct, Mr. Silver, the qualified gaming entities, if they're nationally based, would they still be required to have a server in Maine to address the Maine market, or could they use their servers in other states? They would just link through a website or an interface somehow.
Well, this is an ongoing Wire Act issue that, as states rapidly come on board, they deal with. But, in my opinion, the server should be in the state.
Okay.
Yeah, that's why we have in one of the bills, you have a supplier license. But I'll also add that, and Steve will verify it as well. The casinos themselves already have their sports book division, if you will, already established. So it's not like they're going to go out and search a mobile company to do it for them. They've already established the two casinos for right now. Have already established who they have. So.
Yeah. So I guess that would be kind of my question would be, so if we do go the untethered route, a national company who doesn't have a brick and mortar would still have to find some place to host a server, and they could conceivably use an existing brick and mortar facility to host their service. Is that fair?
Yes.
It could,
yeah.
or they could, lease space somewhere in the state and put it there.
Right. Sure. Okay. And Mr. Silver, how does the tax, and maybe you can answer this, and if you can't, I apologize. How do the tax rates compare? The 10% for facility operators, 60% for mobile operators. How do they compare to those rates nationally? Are they kind of in the middle? Are they high? Are they low?
They're about on par, and there's a lot harder discussion in 2021 than 2019, just based on the number of states and some unique models. So New Hampshire has a unique monopoly where they've got this exclusive deal with DraftKings for 51%. Right, that's a shocking number. But when you look across the board, most kind of fall into that around 10%. Some are a little higher. I think Illinois is 15. Indiana is 9.5. So it's right around there. Just trying to think. Yeah, Nevada I think is 6 to 7%. Which is a old comparison. New Jersey has another 2-tiered split. So New Jersey's 14 and 10. There might be rounding some decimals. I'm wrong on there, but you see a similar split as to what's proposed here. So it's I'm sure the operators would like it to be as low as possible. That's a choice for you all to make.
Understood. And if I could, last follow-up, Mr. Chair. So you mentioned Rhode Island, and I apologize. I'm new to the committee, so I'm not familiar with how. Could you elaborate a little bit on that? What steps we should avoid in those pitfalls? Because you touched on a little bit, but I just want to make sure that we don't repeat and duplicate those similar challenges.
Yeah, and I think it was a concern of the governors at the time, looking at, well, Rhode Island was promised all this revenue, and then it didn't happen. So why should we rush to do it? I think that's a valid concern. But Rhode Island, when they launched, did not have a mobile component, right? It was in person only. So you had to physically go and, place your bet at a sports book. Well, as we know, 80 to 90% of sports bets are placed online. So that's just you cut off a huge chunk of the market. Then when it launched with online first, there was still in-person registration. So you have to drive up, and do that whole process in person to get your mobile account. Again, that cuts out, it's just a step that if people who are already gambling on offshore sites or with their neighborhood bookies, why are they going to drive, to a facility to do it? And then most recently, they came online with fully mobile, dropping the in-person, and you've seen their revenues, go up dramatically.
Thank you.
And they got hit hard because they didn't have mobile, but then didn't they get hit hard when the Patriots won the Super Bowl?
Well, all New England states did. If you look at New Hampshire in particular, it's like $2 million a month in tax revenue every month, except for February because of Tom Brady's win. So eventually Father Time will catch up and the New England sports books will, reap the benefits.
Representative McCrate and then Representative Wood.
Thanks, Mr. Chair. Mr. Silver, I was going to ask you the cautionary tale from Rhode Island, but you already shared that. Could you just define sports book? The language is fluid, and I'd like to make sure we're talking this apples to apples.
Sure, and I apologize if I use some slang or terms you don't know, but the sports book is just the operator, for lack of a better term. So whether it's the facility that you go to physically to place a bet, or the operator of what's on your mobile device.
Great. Representative Wood, are you all set or? Okay. Senator Farron.
Thank you, Mr. Chair. Not exactly sure who to direct this to, but just trying to wrap my head still, with a tethering discussion or whatever, and maybe it's Mr. Silver, but does tethering have is there history with some of the other states or whatever, as far as impact on odds and payouts with the customers, whether tethered or untethered? Is there any data as far as how that affects the consumer?
So let me see if I can answer that. The argument, as I understand it, for untethered would be that, if you tether, you increase costs such that the operators pass that on to consumers via, adjusted lines. That may or may not be the case. We don't have enough, the majority of states are tethered, so you can't really compare it to untethered. What is the bigger issue are license fees, tax structure, and data mandates. So all of those add costs such that your lines have to be adjusted, right? And I can stop if people have questions when we're talking about, minus 110 or minus 120, minus 105, what those lines are, so what the consumer sees. And I think everyone needs to keep in mind that what we're all talking about is a regulated industry we want to bring to Maine, but there is a massive unregulated offshore industry that most gamblers are going to compare, are going to look at, or are already using because they think it's legal. So that is, to me, that the factors that matter more are the licensing fees and the taxation structure.
Representative Chiazzo, did you have a question? Sorry. couldn't
Yeah,
tell.
it escaped me. I was listening to the explanation and I forgot what my question was going to be. So thank you.
Great. And I guess, I mean, as you kind of outlined, it's a policy decision because we are really in all these bills picking the winners of who gets to have a sports book in the state of Maine. Are there many states like Maryland that allow for restaurants or outside owners to have, if you know off the top of your head, I know it's a fluid situation, because I've had restaurants owners in Maine reach out to me and say they'd love to have a shot at this.
Well, I'll say it's coming.
Yeah.
I mean, so, based on where we are in Maine, I'm sure it'll be 10 years instead of 5 years, but it's the next iteration, or they'll just be partnerships. I mean, frankly, with the mobile, you don't really need a physical presence in any of those other types of facilities. But Maryland is the most robust that I've seen. I mean, by far, really cutting in all these different types of stakeholders, carving out protections for minority-owned businesses. That's one of the broadest. And if we had this debate even last year, let alone 2 years ago, and you told me, oh, we're going to have them in sports books and arenas, or stadiums and arenas, that would have shocked me. But here we are.
Right. The leagues have kind of come around a lot on that, haven't they?
Well, and this is what I teach, what I taught the class about. You had almost a decade of litigation, screaming that legalization of sports betting would end the games, right? It would ruin the games. It was evil. It was the worst thing imaginable. Well, now they're in the venues, so apparently it's not that bad.
Yeah. Representative Chiazzo.
Thank you, Mr. Chair. I did recall the question now. If we're looking at a tethered and untethered model, obviously we have a fairly limited number in the state of fixed brick and mortar facilities. Are there other states out there that do, I guess, for lack of a word, a multi-tethered, where you could have one facility have multiple contracts, or is it typically a unique relationship, like one national company might partner with just one fixed company for a competitive arrangement kind of thing?
Yeah, no, you could have multiple skins or multiple, opportunities. Let's put it that way. It's another maybe compromise that the committee wants to think about. Such that you'd be if you go tethered, you'd be inviting more operators. They still got to partner with a brick and mortar, but instead of saying an OTB can only have one, maybe an OTB has two or three.
And is that a practice used in other states, or would that be unique to Maine?
There are other states with multiple skin setups.
Okay, thank you.
Director Champion, did you want to weigh in on that?
Yeah, I would just input that Florida right now is looking at through their updated compact with the Seminole Tribe. They're looking at them hosting, having the server at a location or at the tribal locations, and being able to allow sports wagering at the parimutuel facilities outside of the tribe. So everything's going to be funneling through the tribe. The tribe will get a VIG from all the support, or from the parimutuel facility. So again, I think it's, every state's going to come up with their own little thing, and that's basically what Maine, I think, has to do, is decide what you want to do. But I think the real point here is to make sure that out of the gate we have a mobile application.
Representative McCray.
Thank you, Mr. Chair. And two more definitions, and I know I asked one of these last time. Skin and VIG. I think I asked VIG last time, but I still need to understand.
Mel, do you want me to answer, or do you want to answer?
I don't gamble. Can you tell?
Yeah, well, I'll admit, when I hear VIG, I really think of Milt, just because of his Jersey accent. But
I feel like Milt's going to break my arm when he says that.
Yeah, so that's a shorthand for vigorish. Think of it as the juice, which is a sports book's really trying to balance the amount wagered on each side of a bet. right? In a perfect world, they have the same amount of money wagered on each side, and then make their money off of the vig, which would be, let's call it 10%. So the line is minus 110. So you've got to wager $110 to win 100, right? And that can adjust. You can minus, 105, minus 112, minus 120. That's where they make their money, right? So I think also some that are unfamiliar with gaming think of this as, it's a new class of slot machines or table games. That's not the case. And that's why the margins are so small, because they're trying to get an even amount balanced, and they make their money on that vig, which we see across the country is, about 7% is the hold. So that's the amount the sports books win. That's why the margins are small, and the numbers, although are big to look at on paper, comparatively to other forms of gambling, they're very small. And then what was the second term? Did I miss one in there? Yeah. Skin. So it'd just be like, for instance, an OTB is going to have a license. They're not going to launch, and I'll just make one up. Let's say South Portland OTB Sportsbook, right? They're going to partner with an existing operator that's going to have their name and their branding and all of that. But you may want to give them the opportunity to do that with 3 companies, right? So each of those, would be a chance at a skin. What Milt was talking about with the Seminole tribe, right? They could sign partnerships with, I don't know how many they're talking about, but multiple operators. So they've got a license. I mean, it's technically not multiple licenses; it's one license, but it really is in effect.
And is that limited now in the bills that we have before us?
It would be one per, as far as I've read them.
Okay, thank you.
Mr. Silver, do many states regulate the hold?
You mean like a minimum hold?
Yeah, or anything like that. Well, I know the operators hate it when that even comes up.
It pains me to say it. Tennessee would be the outlier, and I think you all heard about Tennessee in the committee hearing as a cautionary tale, which there's, other than that, I mean, I think it's France is the one country that has a minimum hold, but across the world it just doesn't happen. And the reason is because it's really, I mean, it's probably nearly impossible to have that. And so what you see in Tennessee is, and if anyone's there from here for any of the operators, they can certainly speak to it, but you basically pay a penalty for not hitting that minimum hold. But you can't control that. I mean, you can't control the outcome of the game, and you're trying to do your best to offer lines such that the action is balanced, but that's it shouldn't even be a consideration.
Yeah. And I don't know how much you've studied other countries, but since you mentioned France, do we see tethering in any other country, like a requirement that an online provider is tethered to a brick and mortar?
I don't know the answer to that in other countries. Other than, I will say, if you walk around, London, you're going to see sports betting, little, almost like corner stores, every so often. And you've got kiosks in the stadium. So it's just more prevalent than, I don't know why, but we seem to be scared of it in America.
Yeah, it seems like it's on every corner in London with the William Hill stuff and those companies. Yeah. Great. Any other questions for Mr. Silver or Director Champion this time? Okay, seeing none, thank you both for participating, and I'm sure we'll call on you again in the near future for your expertise.
Thank you.
Yep. So, I guess it's noon. If there's anything the committee wants for information from people while we have them in the attendees list from the industry, we can take that now, or if people want, we can go to lunch and break and potentially table these and pick them up, give people time to digest the information. But certainly whatever the committee wishes to do is good with me. Representative Dolph.
Thank you, Mr. Chair. Just one quick question, and I'm hoping that Director Champion can answer. I noticed in all of Janet's forms and outlays, and it's been brought up a few times, tribal gaming. Would these bills open up more opportunities for the tribes?
Janet, you want to answer that? I think the big factor here is really LD 554. You know, without that, in other words, if LD 554 doesn't pass or doesn't go through, then would be the advantage would be that we've identified that the tribes can participate in this with LD 554 pass, and they don't need the approval.
Right, and so yeah, each of 4 of these bills allow the tribes to have a physical sports book as well as an online sports book.
Right.
2 require, or 2, I guess, would have it through tethering, and 2 would be untethered. They could make an agreement.
And the only thing is just to remember 554 doesn't address the Aroostook Band and Micmacs, so they would have to be in these bills specifically listed at a federally recognized tribe, where you can list that tribe specifically either way to make sure that they are covered regardless of whether LD 554 passes.
Right, and if LD 554 passes, that would just, as this would be considered class 3 gaming, it would enable the tribes to enter into a compact with the state, so, right, on how to set that up. Representative McCray.
Thanks, Mr. Chair. I wondered if we could ask, I know that we've heard from the OTB operators. I see Mr. Sagris or Mr. Barberino. I'm not sure.
Sure.
Who would like to answer a question?
Sure, I'll bring in Mr. Barberino and Mr. Sagris. I see 2 of Gary, so we'll see which one it is. Okay, I think we're getting a little feedback from somebody's.
Maybe it's the other Mr. Sagris.
Okay, yep.
I don't know.
Yep. Okay, oops. Okay, there we go.
So my question is, what Mr. Silver was just talking about with an OTB or a casino or any of the entities that are listed in every bill, if they could have multiple, not multiple licenses, but multiple, whatever the term is. What's the term, Mr. Champion, Director
Skins?
Champion?
Skins, maybe.
Skins? Don't I sound like I know what I'm talking about?
Well, they would have, they would have multiple management personnel doing it for them. And obviously those management operators would have their own servers and that sort of thing. So they would contract with them to perform that you know, those type of wagers.
So with one license, we could craft this to allow multiple management groups. Is that what you just said?
You would either identify by law, or I could do it by rule, that each individual OTB would have to have their own management, or you could do it collectively, you know, all of them together. It's whatever you choose to do. Yeah.
Thank you. And I just wondered if you had a reaction to that idea, Mr. Barberino or Mr. Sagris.
And Mr. Barberino, you're on mute.
Okay, now can you? All right, sorry about that. Offering the OTBs an opportunity to partner with multiple sports wagering companies would be ideal, but not necessary. It would allow more, companies to come into the state partnered with an OTB, and that skins are typical. And New Jersey offers their casinos multiple skins, and Pennsylvania as well as other states. So it is a common practice that's part of the industry.
Okay, thank you.
Okay.
So I guess I have a question for Mr. Barberino. So I'm reading your testimony and you talk about, I guess this year you seem to be very much pro tethering, unlike last session. I guess, can you speak to why you've made the switch?
Yeah, why we supported an untethered bill last time. It was the only bill available. We wanted to have sports wagering. The enormity of the competition, that we want to be partners with these sports wagering companies instead of being competitors, because they're multi-billion-dollar corporations who would dominate the marketplace, and it would be very difficult to compete. Yeah, as you know, 85% of the wagering is done on mobile, and we wouldn't be able to hire a company to do mobile for us because they would all do it independently. That's the reason. And I don't know if it would be financially feasible for an OTB to even open without a mobile component, because it's so important. I know with the ADW bill, we often saw our customers come into our place, make bets on the phone, and the OTB operator didn't get anything, so that was rectified. And I just fear that would be an issue, and we would make it difficult. Also, too, I wonder, I know you spoke about the interstate commerce clause, that with the requirement that the server has to be in the state and that people who wager on sports must be in the state of Maine. I wonder if that even applies. And I'm not a lawyer. I just thought of it as we were listening to the commentary.
Sure. So I guess one last question. I mean, you've talked a lot about how an untethered bill would let money go to these out-of-state companies. Are you a Maine resident?
Am I a Maine resident? I live here, and I also live I commute between Connecticut and Maine. So I live in Waterville. I have an apartment in Waterville, and I spend, predominantly most of my time here.
But you're a resident of which state?
I guess you could say I'm a resident of both states, but I guess technically you could say Connecticut.
Okay.
But the reason I didn't move my family here was because there were too many young kids, and that's why I go back and forth.
Okay, any other questions for Mr. Barberino? And I don't think we have Gary able to get in with us, so. Okay, seeing none, thank you, Mr. Barberino.
Okay, thank you.
Any other questions? Okay, before we, I guess, break or try to clear some of the noise. Any other questions, I guess, or information that we need, to prepare us for the next work session? We can do it now. Otherwise, if people want, we can take a motion to table these four, and we'll schedule a work session in the future once we have a little more time to kind of digest everything and think about all the various elements within these bills. So whatever the will of the committee is. Representative Tuttle.
Yeah, Mr. Chair, I'd prefer that we would table them. I think with all the information that we've gotten and the issue before us, I'd like to proceed with caution and make sure we do the right thing. So at least from my perspective, I'd like to have them all tabled if that would be appropriate, Mr. Chair.
Second.
I
I'll
agree, but would you like to officially make that motion, Representative Tuttle?
Yes.
Okay, motion to table. Okay, is there a second?
Second.
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 Okay, motion to table by Representative Tuttle and
Third.
second. You can't move it and third it.
All right. Everybody here.
No, just kidding. By Representative Riley, I think got it first. So this is to table all 4 bills and we can bring them up again later. So I guess Karen, the motion before us is tabling, and if you would please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Topeka.
Yes.
Representative Topeka, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey. Representative Corey, absent. Representative Dolph.
Yes.
Representative Dolph, yes. 11 voting in favor of the motion, 0 opposed to the motion, and 2 members absent, Mr. Chair.
Great. Thank you, Karen. And thank you, Director Champion. Thank you, Mr. Silver, for helping with that debate. And I'm sure we'll call on you both soon for more information. I think at this point, it's about 12:20, I think it probably would be best for the committee to take a lunch break and caucus kind of simultaneously. And I think maybe we'll shoot for 1:30 to come back in here and take up the remaining bills on our agenda, if that's good with people. So, okay, awesome. With that, we will take a lunch break, a recess till 1:30, and the same link will get you back in here to the meeting. So thanks, everyone. We'll see you in an hour.
What time is the caucus, Mr. Chair? We decided.
We'll send it out now and we can just eat lunch and caucus same time if that works for people.
Okay, I'm like in 3 or 4 different meetings. Wish me luck.
Okay, so yeah, it's a tough time right now with that. All right, see you in 1:30.
So that's
Okay, we'll get started in just a minute with the afternoon's agenda. So. Okay, so welcome back, everybody, to Committee on Veterans Legal Affairs. We ended up tabling the sports betting books this morning, so sports betting bills this morning. So now we'll proceed through the rest of the bills. We've got, I think we're going to start with 587 and 623. Then we'll move to 860 and 1205, and then 1537. So, and Janet, are you here for 1537? I can't remember. You are. Okay, great. Thanks. Yeah, so I guess we'll start with LD 587 and LD 623.
Sorry about that. So LD 587 is an act regarding the licensing of persons to conduct advanced deposit wagering, and LD 623 is an act to amend the advanced deposit wagering laws. Under current law, which was enacted in 2015, the Gambling Control Board is required to develop an RFP process to award one bidder the privilege of conducting advanced deposit wagering in the state for a 5-year renewable license period. These bills would amend that law as follows. So LD 587 would take the approach of increasing the number of ADW licenses that the Gambling Control Board may grant by allowing the board to select up to 3 winning bidders during the RFP process, while LD 623 would repeal the RFP process and allow the Gambling Control Board to issue licenses to any eligible applicant who applies for a license to conduct ADW in the state. So then I just put together a little chart. The left-hand side, or the middle column, depending on how you count it, is current law really, with the one minor change that's made by LD 587 in red. And then the right-hand side is the different approach that LD 623 takes. So the first, just to understand what is ADW, what are we talking about? Well, it's wagering on horse races, when the wagers are made by telephone or over the internet or through an electronic device, where the person making the wager has set up an account with the ADW provider, and they say, I want to place, a $100 bet on this race, and the ADW provider takes the money that's already pre-deposited in the account and uses that money to place the wager, and then whatever winnings might happen, they deposit then back into that account. So it's kind of like internet horse betting as opposed to an off-track betting facility where you have to go place the bet in person. That's my understanding. That's pretty much the extent of my understanding, though. So more technical questions, I hope you will ask somebody in the industry. I will point out that there's slight language difference in the definition. So in current law, it's talking about wagering on harness or thoroughbred races. Under 623, which moves to a licensing system, it talks about wagering on horse races. And then under current law in LD 587, it talks about wagering by telephone or electronic device. And 623 would change that to by telephone or internet, mobile device, electronic communication, or an other electronic medium if it's approved by the Gambling Control Board. So the number of licenses under current law, it's one provider selected through the RFP process. So LD 587 would change that to up to 3 of the bidders would be selected through the RFP process. By contrast, LD 623, which is more of a licensing approach, as opposed to RFP approach, would say anyone who's eligible and applies can be licensed. So who is eligible? Under current law and 587, if you want to submit a bid during the RFP process, you have to, for at least 2 years, have been licensed to accept wagers on horse racing as a commercial track. or an off-track betting facility, or an entity licensed in another state to conduct advanced deposit wagering. Under the approach in LD 623, it doesn't talk about having to have had a license for 2 years. It just requires you to be a licensed commercial track, an OTB, or a multi-jurisdictional account wagering provider, which the definition for that is similar to this bullet point here because it's an entity that's licensed in another state to conduct advanced deposit wagering. LD 623 also provides that the licensee who gets the advanced deposit wagering license can either conduct it itself or it may contract with another entity to conduct ADW. Different from the sports betting bill, it doesn't require some kind of licensing for that contracted entity. It's just you can contract with someone else to conduct ADW. The application fees and the terms of the license are the same under current law as amended by 587 and the new approach in 623. So it's still a $1,000 application fee plus the cost of the background check, an initial 5-year license for $500 and renewals for $250 again for 5-year terms. There's background check required. So under current law, the board, when it's selecting a bidder, can perform background investigations it determines necessary to investigate the suitability of the winning bidder. Although it's not precisely listed in the public law that was enacted in 2015, because ADW, that whole chapter or subchapter, is placed within the chapter of the law governing casinos and slot machine facilities, a lot of the provisions of that law apply equally to ADW, and that includes these two provisions, 1017 and 1019, which talk about the application requirements and consenting to background checks. So again, if you go through the approach in 623, which to remind you gets rid of the RFP process and goes to a more licensing anyone who's eligible process, you still have these provisions apply because it's staying in the same statutory location. But there is an amendment made to 1016, which is a suitability provision that applies to casino licenses right now, and it would apply those suitability requirements to ADW providers. So then it would clarify that the board would be able to refuse a license due to the applicant's lack of good moral character, past felony convictions, any past violations of gambling laws, tax arrears, etc. So all of that the board probably can do now because they can have any kind of necessary conditions, but it would just be clarified in 623 if you went that route. There is, however, an exception in 623, which provides that the multi-jurisdictional account wagering providers own its parent companies or its affiliates past violations of Maine's ADW laws would not be a grounds to disqualify it from licensure. So that's a difference in the two approaches. There are additional considerations either for granting the bid under the RFP process of current law or for licensure under the approach in LB 623. Some of them are very similar. So even though they're slightly worded differently, you always have to have a system to ensure somebody's at least 18 years of age when they place a bet, and they have to be a resident of the state. You must have sufficient financial assets and responsibility to conduct ADW. And the board either can or must require the purchase of a bond to secure all the money that's in all of your accounts from your people who've signed up to place bets over the telephone or internet with you. There's an additional requirement in LD 623 that the applicant have sufficient knowledge and experience in the business of advanced deposit wagering to effectively operate that business. Under both approaches, you have to consent to the board's review of your records and financial accounts to ensure compliance monitoring. Under current law, the RFP process and 587, which just increases the number of bidders that can be selected, there's no requirement for employee licensing for the advanced deposit wagering licensee. There is that requirement in LD 623, however, unless you're a multi-jurisdictional account wagering provider. Remember, that's an out-of-state licensed entity. You might be an in-state entity, but you're licensed out of state to provide ADW. So if that's happening and your employees aren't processing Maine residents' wagers, or they're licensed in another state, then you wouldn't need to also get them licensed in Maine. There's a whole provision of the current law, which is not amended in either of these bills, which talks about the types of rules that the Gambling Control Unit director must make for advanced deposit wagering, and they're not amended in either approach. So I'm just going to move past those, but we can go over them if you want later. As far as the tax rate, because it's an RFP process in current law, the way it was set up is when you apply or submit your bid, you would propose in your bid the percentage of wagers that you would pay to the board for its administrative expenses, and then the percentage of wagers or commissions that you receive that you would propose going towards the state revenue cascade under ADW. As far as under the approach in LD 623, because it's a licensing scheme and there's not bidding involved, it just sets a flat 5% tax on gross ADW income, which is defined as the total amount of wagers by Maine residents less the payment of money to winning bettors. And there's no requirement to have a certain percentage of the money go to the board for admin expenses in 623. The tax cascade is not changed. So there's a certain tax cascade for revenue from bets on in-state races, because remember, advanced deposit wagering is basically off-track betting, but it's not in person. It's sort of over the phone or the internet. And so the tax cascade is not changed. It's the only thing really that's changed in LD 623 is to set that 5% tax, and then you divide it up as defined already in current law, as opposed to current law where the provider, when it submits its bid, indicates what the tax rate will be, and then it's divided up as set forth in this chart in current law. As far as operating without a license under both current law and either bill, the unlawful gambling penalties, which we talked about this morning related to sports betting, they would apply. So it'd be a Class B crime if you accept more than 5 bets worth more than $500 within any 24-hour period and you don't have an ADW license, or if you don't accept that many bets or worth that much value, it'd still be unlawful gambling, a Class D crime, if you profit from any kind of ADW-like activity without a license. Current law also requires specifically that the board send a cease and desist notice to anyone who facilitates or accepts ADW wagers without a license if they're accepting them from Maine residents. So again, as I said, LD 623 follows that same, even though it's not stated in there, those same unlawful gambling laws would apply and the same penalties. It doesn't specifically state in LD 623 that a cease and desist notice should be sent, but it doesn't prohibit the board from sending out a cease and desist notice. It just doesn't talk about it. But there is an exception to the penalties in 623, which says if you're a multi-jurisdictional account wagering provider, you can't be found in violation of any state law. So that would include the unlawful gambling penalties we talked about, based on your own, if you're the provider, your parent companies or your affiliates unlicensed offering of advanced deposit wagering in this state before the effective date of the legislation. Sorry, I'm trying to open my folder in case I have additional notes written down. I was reading a bunch more cases over our lunch break and I don't want to miss the notes I took on them. Okay. Okay, I did want to clarify, I was getting confused with sports wagering. That's where I was looking. So this multi-jurisdictional account wagering provider does have to be an entity that's domiciled outside of the state. So if you're licensed in another state and you aren't a Maine company, then that's who these multi-jurisdictional account wagering providers are. I just wanted to clarify that because I was confusing myself from sports betting, which takes a slightly different approach. So in the past, in the 129th legislature, a majority of this committee favored an amendment to what was then LD 1797, an act to amend the advanced deposit wagering laws. And that amendment was nearly identical to the proposal in LD 623. And the bill as amended was placed on the special appropriations table, but stayed there when the legislature adjourned due to the coronavirus pandemic. So it didn't ultimately get enacted. There is federal law that's involved in this area. It's the Interstate Horse Racing Act of 1978. Under that law, an off-track betting system may accept an interstate off-track wager, which is defined as a legal wager placed in person, by telephone, or electronically in one state on a horse race conducted in another state, as long as the wager is lawful in each state involved. So under the federal law, you can accept this interstate off-track wager only if you obtain consent from 4 entities. It looks like 3, but it's actually 4. So first you need the consent of the host racing association, which is the racetrack that conducts the race that's the subject of the wager. That host racing association, however, can't consent unless it also gets the consent of the horsemen's group, which is defined as the majority of the owners or trainers racing at the track. So even though it's one consent here, the host racing association, it's actually both the consent of the track that's out of state where the race is being run and the majority of the owners and trainers there. You also need the consent of the host racing commission, which is the entity that regulates the conduct of horse racing in the state where the race is taking place, as well as the consent of the off-track racing commission. So if you're the OTB, that means the commission that's regulating you in the state where you are. So the consent of all of these entities is required before an OTB or an ADW provider can accept a wager on a race that's conducted on a horse race in another state. And the reason I bring that up is there was a proposal at the public hearing to amend the bill either to do one of the following: to remove the provision of the bill that authorizes the out-of-state multi-jurisdictional account wagering provider to obtain an advanced deposit wagering license, even if it or its parent or affiliated companies engaged in previous unlicensed acceptance of ADW wagers in the state. So either take that out, or they proposed requiring as a condition of such an entity obtaining an ADW license that any entity obtaining the ADW license that also conducts horse racing must provide the signal of those races to OTBs in the state at a cost no more than 0.5% greater than their best customer. So I was a little bit confused by this proposal. If you want to move forward with it, I would suggest clarifying what's meant by the best customer. Would that be the best customer from the ADW's perspective or the OTB's perspective, which is the customer that got the lowest rate for buying the signal? Or would it be the best customer from the perspective of the racetrack, which is the customer that paid the highest signal or the highest rate? Or maybe best customer because it's been with them the longest? I'm not sure, but that might need some clarification. And then it's not entirely clear whether this condition would be preempted or not under federal law. That's the kind of cases I was reading all during lunch. I will say, to remind you that the Interstate Horse Racing Act of 1978, which I said outlined above, requires consent of 4 different entities before you can accept an interstate wager on a horse race. It requires each OTB, and ADW to obtain the consent of the host racing association, as I mentioned, which is the racetrack hosting the race, prior to accepting interstate wagers on races conducted by that track. It is possible that a court might conclude that requiring the out-of-state racetrack to offer its signals to everyone in the state at a mandated contractual rate conflicts with and may therefore be preempted by the federal law's grant of authority to the racetrack to establish the terms under which it will consent to the placement of interstate wagers. So I gave here an example of a case that involved an Ohio law. So remember, I said that 4 different types of entities have to consent before you can accept an interstate wager. One of those entities that must consent is the horsemen's group, which is the majority of trainers and owners at the out-of-state racetrack. And in Ohio, they had passed a law that said that if the horsemen's group was found to have unreasonably withheld its consent, then the state racing commission, the Ohio Racing Commission, could come in and say, no, that was unreasonable withholding of consent. go-ahead racetrack from Ohio, you can allow OTB providers in other states to accept wagers on your races. That's fine. We'll just kind of override their failure to consent. And the courts in that case decided that Ohio law was preempted because you have to allow each of the 4 entities listed here, you have to allow each of them the opportunity to say no. They called it the horseman's veto. There's also the host racing or the racetrack's veto. There's each of the commissions have their own right to veto. Every one of those entities has to be able to say no. So it depends really how this provision is written, this requiring the signal to be provided at a certain rate. If it says, if the amendment is crafted to say because you decided to obtain an ADW license in Maine, you now must always broadcast your signals in Maine. And in doing so, you must do so at this rate or this price. I think that would be very problematic because you're taking away the right of that out-of-state racetrack to not want its signal broadcast in Maine and not to have any OTB wagers placed in Maine. But if it's drafted a little bit differently, I did come across a case involving a law in another state where it said if you're an out-of-state track and you consent to allowing somebody in the state, so some OTB provider, to have your signal and to accept wagers on your races, then you have to allow all OTB providers a similar deal. You can't exclusively offer somebody a better rate. That was said to be okay because it was still up to the out-of-state racetrack whether they were allowing their signal to come into the state at all. They still had the chance to veto that. But once the consent was given, then it was allowed, the courts allowed the state where the signal was being sent to then regulate how the signal was being distributed and whether it was being distributed on fair terms. So it really would be delicate drafting, but if you want to go down that road, we can talk about it a little bit more because I've probably just confused you all, in which case I apologize. There are some technical issues. So for both bills, this is sort of a theme today. The way that current law is written about who can receive the money from the ADW tax cascade, it's one of the eligible categories is off-track betting facilities that are licensed under 275D. They, as a group, get a share of the ADW tax revenue, and they divide it amongst themselves evenly. But as we've mentioned, under Public Law 2019, Chapter 626, that was enacted in the 129th legislature, there was an additional OTB license issued, and that OTB license was not issued under Section 275D. So under current law, that particular OTB would not have a right to share in the ADW tax cascade revenue. Both 860, LD 860 and LD 1405, the sports betting bill we talked about earlier today, would amend the law in an attempt to say that if you're an an OTB that was licensed under that public law, you have all the same rights as an OTB that was licensed under the existing statute. And I think those would then allow that particular OTB provider, which at the moment is Scarborough Downs, to benefit from the cascade. You could obviously include that in any of the bills before you hear about ADW if you wanted to. I just wanted you to know that is a technical issue, and depending on what happens with the other bills, you may be affecting who gets the ADW money. Under LD 587, which goes from one bidder being selected from the RFP process to up to 3 bidders being selected, I didn't know if the intent was that the Gambling Control Board would be required to issue a new request for proposals and then select up to 2 additional licensees, or whether it's really in its discretion, whether it feels like it needs to allow more licenses. It's not entirely clear to me from the way it's drafted. And then if it does issue an RFP, is it required to select 2 more bidders, or will it have the discretion to say, well, we've got all these bids, but none of them really provide Mainers with a good deal, so we're not going to issue any more licenses. So that might be worth clarifying. if you let me know what you intend, and then I can make sure that I interpret that and that maybe the Gambling Control Board interprets it the same, just to make sure your intent goes through. If you do switch to the licensing process proposed in LD 623, the definition of gross advanced deposit wagering income, the way it's currently written is a little problematic. And remember, this is the income upon which all the taxes are placed. So it's defined right now as the total amount of wagers placed by residents in Maine via advanced deposit wagering before payment of money to winning bettors. So if you're an out-of-state multi-jurisdictional account wagering provider, you might get, let's say, $1,000 worth of bets from Maine residents, and maybe the actual whole pool of bets you have is $100,000. And the amount of payout on that pool, I have no idea what actual figures are. I'm making these numbers up from complete ignorance of the horse racing industry. But let's say you accept $1,000 of your whole pool is from Maine residents, but the payout is $2,000. Then as I read the definition of gross advanced deposit wagering income, you have no such income, because once you subtract out the winning payments, you have nothing left. And I don't think that was the intent. So it may be that you want to consider amending that definition to say that the revenue that's going to be taxed is the total amount of wagers placed by state residents less the payment of money that's winning money to residents of the state. Now, I don't know if that's exactly how people want to move forward, but it did just strike me as an issue when I reread the definition this week, that it could end up with the state getting no money from these multi-jurisdictional providers if they're accepting bets from all over the country. Then I did think it was slightly inconsistent in LD 623, where it says that one of the criteria for obtaining an ADW license is that you have sufficient knowledge and experience in the business of operating advanced deposit wagering to do so. And yet the bill also says you don't have to do it yourself. You can contract with somebody else to provide those services. UL may not think that's inconsistent, but it struck me as worth asking you if you do think it's inconsistent, and what to do about it if you do think so. And then if you look on the bill itself in LD 623, it copies some of current law, which is 1016. And there is a paragraph that appears on page 3 of the bill, lines 25 to 27. It's existing law, because remember, I told you that ADW, the laws are placed within the same chapter of law that applies to casinos and slot machines. Although when the casino laws were enacted, ADW wasn't in there, it was added later. But that current law says if you're a licensed casino or slot machine facility, you can't have more than one license under that chapter. Well, now, if you are saying that a casino that maybe has an OTB associated with it can get an ADW license, that's sort of a conflict. So that might be something you'd want to clear up. It'd be easy enough to do. I just wanted to point it out. And then there's a requirement on page 5, lines 20, that can't be 28 to 20 because that would be negative. So, but there is a requirement on page 5, lines 28 to 30, which says as a condition of getting an ADW license in the state, you have to use a system that ensures that bettors who establish accounts to place bets on horse racing are 18 years of age or older and residents of the state. But again, because you have these multi-jurisdictional account wagering providers, they do establish accounts in other states, and they're maybe operating, maybe they're allowed to establish an account because they're in another state because you have a license in that other state. But it just might be worth clarifying that if you are one of these multi-jurisdictional account wagering providers, you can take bets from residents of any state where you have a license. You're not just limited to Maine just because you decided to get a Maine license also. As far as the fiscal information, it's not yet determined, but there was some fiscal information associated with the majority committee amendment to LD 1797. It was based on a slightly lower tax rate, however, but based on that 4% rather than a 5% tax rate, it indicated that there'd be about $250 in general fund revenue generated from the tax cascade. But by contrast, because it would be now a licensing scheme with anyone who's eligible and who passes the background check being able to get an ADW license, where it was decided, or at least the fiscal note said, that there would need to be another position created in the Gambling Control Board, and that position cost approximately $127,000 for a full fiscal year.
Great. Thank you, Janet. And the fiscal cost was one of the issues with the bills. Like Janet said, it made it to the table and then ended there. Any questions at this time on either of the bills? Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I mean, obviously I have a vested interest in the OTB question, so I'd like to see if we're going to move anything forward. I'd like to see the technical issues surrounding which OTBs qualify. I'd like to see that corrected. To include all OTBs in the state, not just specific to section 275/D.
Senator Farron.
Thank you, Mr. Chair. As always, I think this is a reoccurring theme that we keep saying every time that Janet provides us some analysis here, that it raised some more questions than it answered for me on some of the things. So I would, no, that's awesome, Janet. That's awesome. I would throw out for the committee for a discussion that we look at disposing one of the bills and tabling the other to be able to work on amendments and some language, just throwing it out there for conversation.
Sure. Thank you, Senator. I'm good with doing that. I think I generally tend to oppose both at the moment, but I'm certainly happy to give more time as needed. Representative Kinney.
Thank you, Mr. Chair. With that in mind, I'll move to table LD 587.
Second.
Okay, a motion to table by Representative Kinney, seconded by Representative Tuttle. Any, well, I guess no discussion. Karen, if you would please call the roll.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farron.
Yay.
Senator Farron, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. All 13 members voting in favor of the motion, Mr. Chair.
Oh, got everybody. Thank you, Karen. So that's LD 587 is tabled. Regarding LD 623, I can throw it out there. One of the biggest issues I have in this is the look back that essentially forgives a company for breaking the law previously, as written, for any infraction that may have happened. I can't remember ever actually seeing that in a bill before. So that's one of the pieces that I particularly oppose. Representative Chiazzo.
Thank you, Mr. Chair. Yeah, I would concur. I think we've got a vehicle already. I do have some technical concerns around 587, which I mentioned earlier. So as long as we have a vehicle to do that with, I would move ought not to pass on 623.
Second.
Motion of ought not to pass by Representative Chiazzo, seconded by Representative Tuttle. Any further discussion on LD 623? Okay, Representative McCrate.
Thanks, Mr. Chair. Yeah, I'll support the will of the committee. It's difficult when it's your own bill, but I think we heard a lot of things that we need to work on, and we have another vehicle, so I'll support that. Thanks.
Yeah. Representative Kinney.
Thank you, Mr. Chair. And I certainly understand where Representative McCrate is coming from. And with the other vehicle, I think we should still look at some of the things that are in 623 when we come back to 587.
Any further discussion on this one? Okay, seeing none, the motion before us is ought not to pass. And Karen, would you please call the roll?
Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Hickman,
Yay.
Senator Hickman, yay. Senator Farren,
Yes.
Senator Farren, yes. Representative Chiazzo,
Yes.
Representative Chiazzo, yes. Representative McCrate,
Yes.
Representative McCrate, yes. Representative Tuttle,
Yes.
Representative Tuttle, yes. Representative Riley,
Yes.
Representative Riley, yes. Representative Supika,
Yes.
Representative Supika, yes. Representative Wood,
Yes.
Representative Wood, yes. Representative Kinney,
Yes.
Representative Kinney, yes. Representative Harrington,
Yes.
Representative Harrington, yes. Representative Corey,
Yes.
Representative Corey, yes. Representative Dolph,
Yes.
Representative Dolph, yes. All 13 members voting in favor of the motion. Mr. Chair.
Sorry. Thank you, Karen. So unanimous on the not to pass motion. We'll schedule, everybody's here, so we'll schedule the other bill likely for next week, as that's technically our last week that we have permission by the permission system that the presiding officers are going through at the moment. So next up on our list, we can move to LD 860. If you can, Janet.
LD 860 is an act to clarify the laws concerning off-track betting facility licenses. This bill would amend the laws governing those licenses to authorize the transfer or assignment of an OTB license and to clarify the rights and obligations of an OTB that was licensed under Public Law 2019, Chapter 626. So first, regarding transfer or assignment, under current law, a hotel, Class A lounge, Class A restaurant, or a Class A restaurant lounge, as those terms are defined in the liquor laws, may obtain an OTB license upon approval of the municipality and the State Harness Racing Commission. Current law prohibits the subsequent transfer or assignment of the OTB license, however. The bill would instead authorize an OTB licensee to apply to the State Harness Racing Commission for approval of a license transfer or assignment. Under the bill, the commission may deny the request for one of the reasons that's set forth in current law as a ground for a municipality to deny an initial OTB license application. So under the bill, if you apply to transfer your OTB license, the commission can deny that transfer based on the conviction of the applicant or its majority shareholder of a Class A, B, or C crime. In the olden days, that would have been called a felony, but we don't really refer to them that way anymore in Maine. Also based on the facility's non-compliance with local zoning or land use ordinances, or any waste disposal, health or safety, or repeated parking and traffic violations by the facility's patrons or employees, or any other unreasonable disturbances or interference with nearby residences or businesses' ability to use their property in a reasonable manner, as well as repeated breaches of the peace or disorderly conduct or vandalism caused by the facility's patrons or employees, or a violation of any of the laws governing OTBs. In addition, the second topic in the bill is to clarify The rights and responsibilities of OTBs licensed under that Public Law 2019, Chapter 626. So ordinarily, OTBs are licensed under Section 275-D of Title 8, but under this public law, which was enacted in the 129th legislature, the Harness Racing Commission had authority to issue an OTB license if a commercial track ceased its operation prior to March 1st, 2021, under certain conditions, then notwithstanding the requirements of the current law, which is Title 8, Section 275-D, the commission was allowed to grant a license to that operator of the former commercial track that closed it under the conditions stated here. And it would then have an OTB license. So Section 2 of the bill provides that an OTB that's licensed under this public law has the same rights and privileges and is subject to the statutes and rules applicable to the holder of a license under 275-D as of the date of the licensee's application being granted. So what does this mean? Well, first, let's talk about the sponsor's proposed amendment involving transfer of an OTB license. So at the public hearing, the sponsor proposed amending Section 1 of the bill to clarify that in addition to the discretionary grounds for denial of the application to transfer the license that are established in the bill, the commission would also be required to deny the transfer unless the transferee or assignee would operate the off-track betting facility in the same municipality as the existing off-track betting facility. So that's the transfer provision. As far as the second part of the bill, which is about the rights and responsibilities of the OTB that's licensed under the public law enacted in the 129th legislature, it's worth noting that the one paragraph approach in LD 860 is approached slightly differently. Well, depending on your definition of slight, it's approached quite differently at LD 1405, which is President Jackson's sports betting bill, which we talked about earlier this morning. So under LD 1405, it would provide as follows. And that's all in Part B of LD 1405, which I've attached here for you. So if you printed this out, you can look through that and you can see exactly how it amends the laws. But first, it amends the definition of off-track betting facility and the definition of off-track betting license that is used in Title 8. And it would amend the definitions for all the laws governing harness racing to clarify that the phrase includes both off-track betting facilities licensed under 275-D and those OTBs licensed under this public law from 2019. In addition, it would enact an entirely new statute, which is 275-P. There's a lot of dashes in this harness racing world. So under that new statute, it would specify which subsections of 275-D, remember 275-D is the current OTB licensing statute. So this new provision would say which provisions within that statute apply if you obtained your license under the 2019 public law. So generally speaking, the provisions of 275-D, which is the current law that involve the initial application and licensing process, would not apply to the OTB that's licensed. Well, I'm just going to call it Scarborough Downs for now because we know that that's what it is. So although the provisions of 275-D that involve the initial application process for getting an OTB license wouldn't have applied to Scarborough Downs, the following provisions would be applicable. So subsection 1, which talks about the type of facility, remember that's hotels, Class A lounges, etc., that would apply to this new licensee. In addition, the requirement that you renew your license annually and pay the $250 fee, that would apply. In addition, the requirement that as an off-track betting facility, you exclude anyone under age 16, and then you don't allow anyone under age 18 within a certain area of the betting window, that would apply. The requirements that are stated in the statute about simulcasting of races, including the approval of the racetrack and the use of monitors in the facility, all of those would apply. The prohibition on transfer and assignment of the license would apply. That's the language of that talks about it being a prohibition on transfer or assignment. If you wanted to move forward with incorporating this approach into LD 860, we just have to slightly modify it because now it's not going to be a prohibition on transfer. It's just going to be a restriction. That's easy enough to do if you want to sort of incorporate these together. In addition, LD 1405 specifies that the license revocation, including procedures of current law, apply to this new OTB, including the automatic revocation if its majority ownership changes. In addition, the provision of current law that says that the commission has to approve the dates on which the off-track betting facility can conduct wagering, that would apply to the new OTB, as well as the authority of the Harness Racing Commission to impose conditions on the licensee. I think that usually applies if they've had some violations in the past, they might impose some conditions. So that would apply to the new OTB as well. In addition, LD 1405 has a paragraph that's very similar to the one paragraph that's in LD 860, which provides generally that an off-track betting facility licensed under the new law has all of the other rights, privileges, duties, and restrictions as an OTB licensed under current law. In addition, like LD 1205, which we haven't gotten to yet, it reduces by half most of the taxes imposed on the commissions that an off-track betting facility collects on wagers that are placed on out-of-state races if the OTB was licensed before January 1st of this year. There's way too many numbers in there, but that's supposed to be this year. And if that OTB is not eligible to receive a distribution from the fund to stabilize off-track betting. Without getting too much into LD 1205, I'll just say that the fund to stabilize off-track betting gets some revenues from the casino cascade. And when it was enacted, it said that if you're an OTB now, then you can get a share of those revenues, which means that if you're a new OTB, like the one under Public Law 2019, Chapter 626, so that new OTB is not eligible for that casino cascade money through this fund. And so what President Jackson's sports wagering bill does is it reduces some of the taxes imposed on the wagers that type of OTB collects as an idea, I guess, to offset the fact that it doesn't get this other revenue. That's included as well. In addition, under President Jackson's approach to clarifying the rights of this new OTB, it would authorize the OTB to submit a bid for advanced deposit wagering license. So we talked a little bit about that in the last set of bills. And it would also authorize the OTB, this new OTB, to receive distributions from the revenue of the ADW cascade. Although I do think there's an error in 1405 that you can correct either in that bill if you move forward with it, or in this bill if you incorporate it, or maybe you don't think it's an error. But the way that 1405 is currently written, it says that if you are this new OTB that was just recently created, then you can get a share of the revenues from the ADW cascade for wagers placed on races within the state, but not for wagers placed on races out of state. I do think that's a drafting error. I might know the drafter. She might have made that error. But that's up to you to decide whether it's an error or not. In addition, LD 1405, which is President Jackson's bill, when it addresses this topic, it also actually amends that 2019 Act to specify that the OTB that it eventually got a license under that act is subject to this new provision of law 275P, which clarifies what provisions apply. And I might say the reason why that might be necessary is if you remember this 2019 law, which said there can now be another off-track betting facility, said that it could open notwithstanding the requirements of current law. And so what President Jackson's bill says is, maybe you got your license notwithstanding the requirements of that law, but you are now subject to this new provision of law that's been created that says you have to follow all of these rules, like excluding minors and only offering races on certain dates, etc., and so forth. So very relatedly to this, I would say if you want to go forward with the more streamlined approach in the current bill, it may still be worth amending that old public law 2019-626 to clarify that even though it says notwithstanding the requirements of 275D, you are allowing some of those requirements to apply to this new OTB. So that's up to you. But if you don't understand what this means, then you should just look at that provision of Senator Jackson's bill, which is attached to the bill analysis, to see how that would work.
Great. Thank you, Janet. Any questions? Representative Chiazzo.
Thank you, Mr. Chair. Thank you, Janet. That clarifies a lot of my concerns, certainly in general about the one OTB that was created by that other standalone law, which is Scarborough Downs. So I do like Section B of this bill, but I do think that that issue is probably better corrected in a different vehicle, such as 1405. So, and I'm not a real fan of transferring licenses either. So I'm inclined not to support this bill that's in front of us right now.
Senator Farren.
Thank you, Mr. Chair. I guess a question, talked about a little bit about the pieces that clean up. I do agree. I think maybe 1405, if that passes, that's the if that passes, does some of those. And I'm not totally comfortable putting all the eggs in the basket we just heard them this morning, and there's 4 of them, 4 different bills that were taken up through there. And 1405 is the one that kind of addresses this transferability and some cleanup of the language. So I'm kind of leaning more towards supporting this and maybe holding it in the committee for just a little while we work through the other bills and see what does come out of the committee. So that's just kind of my thought.
Sure. In terms of timeframes, we can hold bills, obviously, as you know, but I will say beyond the 21st, there's no guarantee we get to meet again. That's what the presiding officers have said. Unfortunately, given the session, it's kind of crazy that they expect that, but yeah.
We'll meet incognito.
That's right. That's right. Representative Chiazzo.
Thank you, Mr. Chair. No, and I appreciate that approach, Senator Farren. I think I feel like something will move forward in sports wagering, and I think in my mind, there's always 2 ways to skin a cat, right? We can try and divide and conquer and piecemeal it, or we can try and put it all under one. And I feel like I feel in this instance, probably putting it under one, I think there's enough vehicles and mechanisms over there for to accomplish that. So I appreciate what you're saying. I still think that this is probably not a bill I could support, but I would like to see those issues brought up and put into another vehicle, whether it be 1405 or something else that kind of closes this loophole a little bit.
Sorry, my internet is being unstable at the moment. I missed that, Representative Chiazzo. Did you make a motion or anything? I missed.
No motion yet, Mr. Chair. No.
Sorry, I kind of froze for a while. Representative Tuttle.
Mr. Chair, I move ought not to pass.
Okay, we have a motion of ought not to pass by Representative Tuttle. Is there a second? Sure. Is there a second to that motion?
Second.
Okay, thank you, Representative Riley. It's hard to see everybody. Any further discussion? Senator Farren.
No, I'll just say, Mr. Chair, just following back up on this, is I'm going to oppose this motion, but if we do move forward with 1405 and we get that, then making sure that we get those provisions in, we'll just let things ride.
Sure. Yeah, and I'll just, so everyone knows, I'll be supporting the motion because I do have issues with transferability of these gambling licenses. So, especially when they get coupled with sports betting as we move ahead. So any other discussion or issues? All right, seeing none, we'll proceed to a roll call vote. Karen, if you please, and the motion before us is ought not to pass.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
No.
Senator Farren, no. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington.
No.
Representative Harrington, no. Representative Corey.
No.
Representative Corey, no. Representative Dolph.
Yes.
Representative Dolph, yes. 9 in favor of the motion and 4 opposed to the motion, Mr. Chair.
May I ask for the minority report?
Yes. Gina, I'd like to have the minority report be ought to pass as amended in on that technical issue. I'm going to get all the numbers wrong, but 2019 275D. I wrote out some notes as you was going through, but that conflict piece that you were speaking about at the end.
So don't take the approach in the sports wagering bill. Instead, just slightly amend 2019.
You got it.
Okay, and do you want the sponsor's amendment about transferability?
And yes, that it's got to stay in the same municipality. Is everybody else on the minority report? Any other comments?
Yeah, is everybody else good with that, or?
Yeah, I'll go with that.
Okay, thank you.
It's like Hollywood Squares, looking around for faces and nods. And
It's so hard. It is so hard, man. I feel like I'm looking down a river where Representative Corey used to sit. There he is. Are you good with that, Representative Corey?
I'm good with that. Sorry, I was letting the dog out. So.
The mouse remover, Mr. Chair. Yeah.
Okay, are you all set, Janet?
Yep.
Okay.
Just need to write it down.
Yep.
Mr. Chair, while Janet's doing that, I can't help but notice while Senator Hickman just dropped off, but he's got a smile on his face and a little kick back. He must only have one committee today. He seemed a little more relaxed.
Doesn't he had, I think he had both today, but he's free now from one.
Oh, okay, that's what it is. I just,
I think you missed me earlier when I said I presented, or maybe that was my other committee. Yeah, I saw the kids last night at the National Honor Society induction at the high school. Got my nice bling, and kids always be happy. So
good.
It's gonna go for a while. Thanks.
It's good to do stuff like that again too.
Yeah.
Yeah.
Yeah. All right. Next on our list, we have LD 1205, which is an act to ensure equitable taxation of off-track betting facilities.
Okay. So this bill amends the current law, which is in Title 8, Section 286, to reduce by half the taxes imposed on the commissions an off-track betting facility collects on wagers with commingled pools placed on out-of-state races, if the OTB was licensed on or before January 1st of this year and is not eligible to receive distributions from the Fund to Stabilize Off-Track Betting Facilities. At the public hearing, the sponsor explained that he did not intend to reduce the state share of the taxes on the commissions collected by these OTBs for these wagers. So he didn't want to reduce the state share, he just wanted to reduce the share that went to other types of funds. So he requested that the committee consider amending his bill to match the analogous provision of LD 1405, which is Senator Jackson's sports wagering bill, which is attached to this bill analysis. If the bill is enacted with this proposed amendment, the tax imposed on off-track betting facilities commissions from commingled pool wagers placed on out-of-state races will be as followed. So if you receive funding from the Fund to Stabilize Off-Track Betting Facilities, then you're in this middle column. And if you don't receive funding from the Fund to Stabilize Off-Track Betting Facilities, you'd be in the right-hand column. So the state share for all of those wagers would be the same. It wouldn't matter whether you receive the funding from this this fund, which comes from the casino cascade. It wouldn't matter. The state share would be the same. And there are two rates, but it depends on whether your off-track betting facility has a commercial track in the same municipality. Basically, these numbers can really kind of boggle you if you try and read through the statute, at least if you're me. But those rates would be the same for the state share. But everything else, the Sire Stakes Fund share, the stipend fund share, the purse supplement share, the harness racing promotional fund share, and the off-track betting facility simulcast fund share would all be reduced by half. In addition, if you have an exotic wager that's on an out-of-state race and it has a commingled pool, then again, the state share would be identical. It wouldn't change whether or not you get money from the casino cascade, but everything else, all of these funds share. So the Sire Stakes still, stipend fund, purse supplement, harness racing promotional fund, and the off-track betting facility simulcast fund, all of those shares would be reduced by half. And just so you know, the state share is calculated as this percentage that's listed in the table of the off-track betting facilities commission, which is defined as all wager amounts not paid or payable to persons as winning wagers. All of the other funds shares, however, and just so you know, that state share is generally used for the administrative expenses of the Harness Racing Commission, although if it exceeds $35 million a year, there is a statutory cascade, which you can click on this link and you can find it. All of the other taxes, so all of the other funds that get a share, they are calculated as a percentage of the net commission instead, and that's defined as the total commission that the off-track betting facility receives after the payment of winning wagers, but before the payment of the state share, less 4% of the amount wagered. I don't know why all these definitions are different, but it is worth you knowing what they are. And if you want to know what each of these funds do, I hyperlinked to the statutes for them. We can talk about them if you want to. Some additional information. So the bill is basically saying, if you are an OTB and you get money from the Fund to Stabilize Off-Track Betting Facilities, you have one tax rate. If you don't get money from that fund, you have a lower rate in many of the taxes that you pay. So what is this fund? So the Fund to Stabilize Off-Track Betting Facilities was established in the Public Law 2003, Chapter 687, which was a law that revised the Citizens Initiative that had authorized the establishment of a slot machine facility at a commercial track, and which had been approved by the voters in November 2003. So initially, 2% of gross slot machine income from the Bangor Casino, before it became the Bangor Casino, was paid to this fund to stabilize off-track betting facilities. But under the terms of that statute that created the fund, the amount was reduced to 1% in November 2009, 2 years after the payments began. So the fund currently receives 1% of the Bangor Casino's net slot machine income. And net slot machine income is all money used to play slot machines, less the prizes paid to winners, and less the 1% that is paid to the general fund for the administrative expenses of the Gambling Control Board. So all of the net earnings, less that 1% to the Gambling Control Board, are taxed at a 1% rate, and that goes to the Fund to Stabilize Off-Track Betting Facilities. The fund does not receive any revenue from the Oxford Casino or from any table games. So under Title 8, Section 300, the revenue that's in this fund to stabilize off-track betting facilities is distributed quarterly in equal amounts to any OTB that was licensed and operational as of December 31st, 2003, as long as it remains in operation at the time of the distribution. So this is the creation of the fund in section 300 of Title 8. And then the distribution provision does say you have to have been in existence as an OTB by December 31st, 2003. And then as long as you stay in existence, you can get a distribution from this fund. So why does this matter? Well, it's because of the new OTB that was created in 2019 that we just talked about. So under that public law, an act to amend the laws related to harness racing, under section 16 of that public law, there was the provision to create this new OTB if a commercial track closed under certain conditions. And Scarborough Downs does have that license. And because that license for an OTB was issued after December 31st, 2003, that particular off-track betting facility is not eligible to get any of the money from the casino cascade. And that's going to be the entity that would be affected by LD 1205. As far as the tax rates on OTBs, and this could be my ignorance of what kind of bets they actually take. So if anybody has a concern about this, you should ask the OTBs themselves. But LD 1205 reduces the taxes imposed in this one particular subsection of 286. And those are the taxes on commissions that the off-track betting facility earns on wagers, quote, on simulcasting of races with commingled pools originating at a racetrack in another state, end quote. Those are the taxes we're talking about. It is worth noting, however, that there are two other types of OTB taxes and whole cascades that are set forth in this section 286. So under subsection 6 of that law, there are taxes imposed on the commissions that the off-track betting facility would earn on wagers on simulcasting of races with non-commingled pools originating at a racetrack in another state. So basically the same as the taxes we're reducing, except that the pools are not commingled. I don't exactly know what that means, but it treats it differently. LD 1205 does not reduce those taxes. In addition, LD 1205 doesn't talk about the commission that the off-track betting facility earns on wagers on races that are simulcasted and the races are actually conducted within Maine. So those tax rates are not affected either. It's just this one type of tax rate that is affected by this bill.
Great. Thank you, Janet, for your analysis. Representative Chiazzo.
Thank you, Mr. Chair. I feel like it's old home week here in VLA for Scarborough. It's like every bill we're touching today. I was originally gonna request the bill sponsor to kind of give an overview of why they felt it was necessary to bring this forward, but I think Janet did a fantastic job with that. You know, I really think the goal here is to establish a fair and open competitive marketplace. And I feel like when we have situations like it's been established now through various reasons, we seem to have, we're in a position to be picking winners and losers again, and who gets what and who gets to share in the rewards and who's penalized for what. So I think a lot of this goes away if we can find a way to homogenize the OTBs and treat them all the same way. But until we do that, and to Senator Farron's point earlier about if something happens and none of that stuff passes, I think this is a fair vehicle to say, if you participate in a funding mechanism if you can't participate in a funding mechanism that your competitors do, that gives them an unfair advantage in the marketplace, and this tries to level set that advantage. So having said that, I would move ought to pass as amended with the sponsor's amendment for 1205.
Second.
A motion of ought to pass as amended and by Representative Chiazzo and seconded by Representative Tuttle.
My voice is breaking, Mr. Chair.
Yeah, I could tell it was you though. Mine is too, actually. Senator Farron.
It must be allergies or something. I think everybody's getting a little bit of it. I originally thought that this was kind of a carve out, and after the analysis, because we really didn't receive a lot of testimony. We only heard one that kind of explained it a little bit, but after Janet's analysis of it and understanding this is more about leveling the playing field, I think I'll be supporting the motion.
I just want to clarify, I'm not saying it's level or not. I'm just telling you what I understand the law to be. That's all.
I did not mean to put words in your mouth. My interpretation of your analysis. How's that?
It applies to both of you.
All right. Sounds good.
Janet, we may need your vote on this.
I'm abstaining.
And Janet, are you good on the amendment? I should have asked earlier. You good on?
Yes, it would just basically strike out a subparagraph that shouldn't be there. So if you have the bill in front of you, all it's going to do is on lines 32 and 33, you're going to strike out number 1. Because those are the subparagraphs that talk about the state share. So the state share isn't going to be affected. Or you can look at the end of the bill analysis. I just cut and pasted the provision from President Jackson's sports wagering bill, which doesn't reduce the state share, but it reduces all the others. And that's basically what it's going to say if you vote for the motion.
Okay. And just so I understand as well, so this reduces the tax rate, correct, on the newly established OTB that was created by the Ag Committee?
Yeah, it definitely reduces the tax rate on that one. I don't know enough about OTBs to know if there's any other one that was established after December of 2003. So if there was another one, it's reducing its tax rate as well. I just know that it's reducing the one for Scarborough.
And so I just in trying to understand. So the way it's written, so anything, any facility licensed after January 1st, 2021 will have this new tax rate?
No, it's not written exactly that way. So it's written, if you aren't eligible to receive money from that fund, which is part of the casino cascade, because you were licensed after December 2003, because that's what the fund says, you have to have been licensed before then. So anyone after December of 2003 would be eligible if you're an OTB, but the bill as drafted does say that you have to have become an OTB before January of this year. So any new OTBs after now would not get this reduced tax rate.
Okay, so you were licensed in 2003 and then got the new license this year.
So basically, if you were licensed between 2004 and the end of last year, any of those OTBs, and that has to be your first license.
Okay, thank you, Janet. Representative Chiazzo.
Thank you, Mr. Chair. And Janet, just so I'm clear on this, if Scarborough Downs is allowed to participate in the fund stabilization disbursement, they would no longer be eligible for that reduced tax rate. They would have to go back and pay the same tax rate as all of the other OTBs who participate in that fund distribution. Is that correct?
Yes, the way that the bill is written and also the amendment would be written, unless you direct me otherwise, but the way it's written is it says there's 2 conditions to getting the reduction. One is you had your license before January of this year, and the other is you're not eligible for that fund. It doesn't talk about when you were first licensed, if it was after 2003, it just says you don't get the casino money, then you get a reduced tax rate as long as you had your OTB license before this year began.
Thank you.
Okay, any other questions? Representative McCray.
Thanks, Mr. Chair. Janet, you probably already said this, but why aren't they part of the same system?
I'll show you again.
If you don't mind.
It's definitely confusing. So this is the fund to stabilize off-track betting facilities statute. I don't know, it's kind of small. I'll try and blow it up a little. So that fund, this part talks about that it gets the money from the casino cascade. And then how does it distribute it? Well, it only goes to each of Maine's off-track betting facilities licensed and in operation as of December 31st, 2003. And then the second sentence is they still have to exist. So because Scarborough Downs didn't get its OTB license until after 2003, it's not eligible to receive any of this money. There may be another OTB as well, I don't know, but at least know for them that they aren't eligible for this fund. But the way that the bill is written, and I'm going to show you the proposed amendment language because it is very similar to the bill. It says, so this is the whole tax rate statute. It says this tax rate only applies if you are licensed after January of this year, or if you get distributions from the fund to stabilize off-track betting facilities. If either of those things is true, then these tax rates apply. If, on the other hand, you were licensed before January of this year and you're not eligible to receive any money from this casino cascade, then all of these harness racing shares of your commission are reduced by half.
Thank you. I follow up, Mr. Chair.
Yeah.
Is there an effort to change that? Did you have to have been licensed within that period, or is that just that's just the way it is in law? I guess I just don't.
There's nothing that would stop you from amending that instead or in addition. That's entirely up to you. I don't know about efforts, I'm not really involved in that stuff, but.
Right. So OTBs in Maine who are eligible to get the casino cascade money will have one tax rate, and then those who aren't will have a much lower tax rate.
But only on certain wagers.
Only on certain wagers, yeah. And this was kind of the deal that happened in Ag Committee last session when they created this new OTB. Representative Chiazzo.
Thank you, Mr. Chair. And I guess question to Representative McCrate, if I could, through the chairs. Were you asking about why Scarborough Downs is in the position that they're in to be separate, or why they need to be treated separately?
I guess I'm wondering why it's being approached this way rather than expanding future OTBs, if there are any, to be included. I guess the answer is probably the share would be smaller, but I don't know.
And Mr. Chair, I know Mr. McCall is in the attendee room. He's familiar with the rationale behind it. If we wanted to bring him in, he might be the best person suited to answer that. I know I can't answer that.
Would you like to bring him in, Representative?
Please. You want me to? Yeah.
I got him. I got it now. Yep.
Thank you.
Sorry, the little spotty internet. Sometimes when it's not working well, I can't bring people in. It should be good though. So Mr. McCall, if you can hear us, if you can unmute yourself and turn on your camera if you'd like. Welcome, Mr. McCall.
Yeah, I would just ask Mr. McCall, before you go, could you please just, for the committee, to full disclosure, say who you are and who you're representing, please?
With pleasure, and thank you very much. I've been listening most of the day, and you all work very hard, and you have an excellent staff. My name is Ed McCall. I've represented Scarborough Downs since 1989. I'm in my office in Portland. I'm a resident of Cape Elizabeth. The answer directly to the question as to why the treatment of the Downs is to reduce its taxes as opposed to give it a share of the cascade money for the fund to stabilize OTBs is that this was worked out with all of the participants in the industry who are affected, and the taxes that are being reduced would go to other entities that agreed that they would take less to help the Downs as part of this process of the Downs giving up its commercial track license, another track getting the license. So the way we worked it out, money doesn't come from the OTBs. They're all currently at best marginally profitable, couldn't really take a hit. These other funds get some benefit from the downs existing. The other OTBs don't get any benefit from the downs existing. In fact, they have more competition because the downs existed. So this was worked out as a fair compromise to try to address that issue. It wasn't specifically asked. The reason why non-commingled wagers aren't being adjusted is because there aren't any. When simulcasting started in Maine, it started at Scarborough Downs, and you could go to the Downs and bet on, for example, the Kentucky Derby, and odds were being set based on only the bets placed at Scarborough Downs, and the pools weren't commingled with the pools at Churchill Downs, and that was allowed by statute to happen either way, separate pools or commingled pools with the host track. Everybody commingles their pools now. All those statutes are beside the point, but they've never been eliminated. With respect to in-state wagers, we didn't want to change that because a higher slice goes to purses. Those are real Maine horses. They should get their full share on in-state wagers. So those are all in the discussions as to how we work this out as a fair compromise, and those are the reasons for it. Staff has pointed out that she's not sure whether there are other OTBs that still exist that were licensed after 2003. The answer is there aren't. It only affects Scarborough Downs. I would also point out with respect to why the Downs wasn't licensed under 275D, that was really a drafting issue that occurred with the Ag Committee bill a couple of years ago. As written by the sponsor, Representative Marian, it would have added a section to 275D for allow this license. So we wouldn't have had all this confusion about an OTB that wasn't licensed under 275D. Staff at the time looked at it and said, this looks like really a one-off proposition that'll never happen again. So rather than put it in statute, we'll have it be a standalone provision in the general laws, not in statute. And that just created all the confusion that we're addressing with some of these bills to try to make it clear that all the rest of the law should apply to the Downs OTB. Thank you very much. I'd be pleased to answer any other questions any of you might have.
Thanks. You all set, Representative Chiazzo? Sorry. Yeah, Representative Kinney.
Thank you, Mr. Chair. I was probably part of that ag bill, so I'm trying to figure out which one it was. I found in the 129 LD 1728, I remembered that one, which affected the purses. But Mr. McCall, you mentioned section 275D, which was not in that bill. Do you happen to remember what bill had that section 275D in it? And if it was last session, or was that in the 128th?
So it became LD 1590 of the 129th.
Okay.
But it was submitted as a fully drafted bill, probably written by Bob Tardy, but
most likely
offered by Representative Marian, as I recall, sponsored by Representative Marian, as I recall. As I did with the bills that Senator Diamond's bill here, I wrote it. But then staff changes it the way they think the reviser might want it, and that's what happened here. So you won't find the language that Representative Marian submitted probably anywhere, but his language added a subsection to 275D, which frankly I gave to Bob Tardy, he gave it to Don Marian, and that's how it got to the legislature.
Interesting. I guess my question, so this agreement was, put into an ag bill a couple of years ago. Why wasn't this put into that agreement at the time?
So, and thanks for the opportunity to clarify. These particular provisions were agreed to afterwards and weren't part of the agreement that was in LD, became LD 1590. They were agreed to all subsequently, including in negotiations with all of the entities last fall at the OTB in Brunswick, where we all got together and worked on changes in the law that we think are good for the entire industry, including the sports wagering bill that Senator Jackson submitted.
So, I mean, this, just to be clear, the only person this applies to is Scarborough Downs, right? The new OTB at Scarborough.
Yes, although, for example, if the legislature eliminated the cascade, then it would apply to other OTBs. Or if the legislature decided to include the Downs in the cascade, then the Downs would lose these revenues. But under the current, with respect to existing OTBs, this would change the Downs taxes, and it would only change those taxes that go to other participants in the harness racing community, all of whom have agreed to the change.
So you're speaking for the whole industry. They all support this bill, just so I'm clear.
At the meeting at the Brunswick OTB, representatives of the Harness Horsemen's Association were present, the Breeders Association was present, the Fair Association was present, Mr. Trinket was present. Everybody participated in agreeing to this particular change. That's correct.
Any other questions for Mr. McCall while we have him? Okay, seeing none, thank you for your testimony and answering questions today.
Thank you, Senator.
Okay, any other questions? Sorry about that. Okay, seeing no further discussion, we will proceed to a vote, a roll call vote. Karen, if you please, the motion before us is ought to pass as amended.
Senator Lucchini.
No.
Senator Lucchini, no. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
No.
Representative McCray, no. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
No.
Representative Riley, no. Representative Supika.
No.
Representative Supika, no. Representative Wood.
No.
Representative Wood, no. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington. You're muted, Representative.
Yes.
Representative Harrington, yes. Representative Corey. Representative Corey, absent. Representative Dolph.
Yes.
Representative Dolph, yes. 5 in favor of the motion, 6 opposed to the motion, and 2 members absent, Mr. Chair.
Okay, thank you, Karen. So 5 in favor of the motion, 6 opposed. If all 6 are good with an ought not to pass, then we can just do it that way without re-voting, if that's good with people to save time. So I'm good. Representative Kinney, you're good with that?
Yes, Mr. Chair.
Okay, thank you. Representative Riley, are you good with ought not to pass? And Representative Wood? Okay. Representative Supika? Ought not to pass. Okay. Representative McCray?
Yes.
Okay. Was that everybody, Karen? Sorry.
I'm sorry.
Yeah, I think that was one.
Yeah, you, Representative McCray, Representative Riley, Representative Supika, Representative Wood, and Representative Kinney.
Okay. Okay. So the majority report will be ought not to pass, but we have the 5 on the ought to pass as amended report as well. And just a reminder to anyone absent that we only have till noon tomorrow to vote. So we'll let our caucus members know to cast their vote or else they won't get on record. Okay, thank you, Karen. Okay, next up, I believe is the last bill on our docket today, which is LD 1537.
Mr. Chair, who put this bill in anyway?
Some guy named Tuttle.
Oh, shit. Oh. Okay.
So LD 1537 is an act to restore funding to the Southern Maine Veterans Cemetery from our own representative Tuttle. The bill provides general fund appropriations of $68,162 in fiscal year 2021 to 22 and $89,650 in fiscal year 2022 to 23 to the Department of Defense, Veterans and Emergency Management for one heavy equipment operator 2 position and one groundskeeper 2 position at the Southern Maine Veterans Cemetery in Springville. At the public hearing, the director of the Maine Bureau of Veteran Services submitted testimony, although it was presented by General Young, explaining as follows. Until last summer, the Southern Maine Veteran Cemetery was fully staffed with one working supervisor, one equipment operator, and one groundskeeper 2. Last summer, the equipment operator position became vacant and was difficult to fill because the pay was insufficient to attract appropriate candidates. The Bureau received approval to reclassify the equipment operator position to a higher pay grade in recognition of the duties and responsibility of the position. I would note that in the governor's proposed biennial budget that we went through earlier on this session, it included an initiative to fund that reclassification using general fund dollars. And I've just cut and pasted it right out of the budget, part A below. The VLA committee unanimously of those present voted in favor of that initiative. Although it was not included in the recently enacted biennial budget, the Bureau testified that this initiative remains part of the governor's supplemental budget proposal moving forward. I haven't yet seen the text of that supplemental budget proposal, however, so I haven't confirmed that that's in there, but that was what was represented to the committee at the public hearing. So in addition, the Bureau has issued a request for proposals to implement a seasonal mowing and trimming contract for the Southern Maine Veterans Cemetery, which will be funded with federal revenues. The Bureau intends that this contract will relieve the workload of the existing staff to enable them to focus on completing burials, installing headstones, and completing routine maintenance. There is a preliminary fiscal impact statement, and it provides for the money that's directly in the bill. So that's not too surprising.
All right, thank you, Janet. Any questions for Janet on the analysis? Any questions at all from the committee? So I guess from my perspective, I mean, I think, you know, Director Richmond's in the attendee room. Maybe we bring him in to we haven't seen the governor supplemental yet, so we don't know if it's in there. But I'm assuming they wouldn't have submitted, but perhaps he could let us know if that was part of the package that they submitted. Again, not seeing it. It may have just come out. I haven't seen it yet myself, though. Let me see if I could bring Director Richmond in.
Good afternoon.
Welcome, welcome, welcome.
I've hung in since 10 o'clock today, and it's great to see you all. I can see you, but I'm afraid my internet's pretty sketchy, and with your permission, I'll leave my camera off.
That's fine, Director Richmond. We appreciate you hanging in with us. I just wanted to bring you in to confirm that this initiative was included in the budget requests. Or will likely be included in the budget request from the governor.
I believe there'll be a testimony before appropriations tomorrow, and it's my understanding that our initiative that I mentioned in the testimony that day will be in there.
Okay. Thank you, Director Richmond. Any other questions from the director? I just wanted him to confirm that it was part of that submission. No other questions. Okay, thank you, Director Richmond. We're sorry to string you along for that one sentence answer, but it was very helpful for sure.
It was my pleasure. It's good to see you all.
Any other comment or question from the committee?
Mr. Chair, if I could.
Yeah, please.
It's my hope, as most of you know, I've worked on the Southern Maine Veteran Cemetery for the last 20 years, and I've worked with Dave Richmond, respect him highly, but having been involved with the appropriation process, I'm hoping that it does go through, and I'm probably pretty close to saying it will, but I just would like to have this vehicle maintained temporarily to assure that occurs. So if somebody would like to table that until we find it out, I'd greatly appreciate it.
Thank you, Representative Tuttle. Representative Kinney.
Thank you, Mr. Chair. I would make the motion to table, I don't have the number for me, 1537, LD 1537.
Second.
Who was that second? Representative Wood? Okay. And that was okay. Tabling motions end debate and discussion. So
third, Mr. Chair.
Karen, when you are ready, please call the roll.
Senator Lucchini. Senator Lucchini, absent. Senator Hickman. Senator Hickman, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey. Representative Corey, absent. Representative Dolph.
Yes.
Representative Dolph, yes. 10 in favor of the motion, 0 opposed to the motion, and 3 members absent, Mr. Chair.
Thank you, Karen. Motion to table is successful. We'll put that one aside and hopefully get some insight from the governor's budget proposal and AFA as well. I think that's it. I see Senator Lucchini's back. So I think we're done with the bills we have scheduled for today, but I'll turn it over to Chairman Lucchini to see if there's other things on our docket.
Thanks, Mr. Chair. Janet, did we have anything else pop up or from the revisers? Are we pretty good to go?
There might have been a few things come in, but I'll just put them Friday.
Okay.
So I can have time to scan them and mark them up.
Okay, cool. So Friday I think we're at 10 o'clock. Right. Yeah.
Yes.
That'll give time for people to caucus in advance. Representative Tuttle.
Yes, Mr. Chair, I'd like to announce that the Over the Hill gang of the Veterans and Legal Affairs Committee will be meeting 6 a.m. in the legislative parking lot. I expect you all to be early.
6 a.m., huh? Representative Chiazzo.
Thank you, Mr. Chair. I guess, so I just want to remind everybody, we did such a good job the last couple of weeks or so. We're going to take tomorrow off. So we don't have anything scheduled for tomorrow. But just remember, we do have session next week. So it's going to be pretty hectic from here on out. But enjoy your time off tomorrow for those of you with other committees. I'm sorry to hear you'll be working over the weekend, but we have been so efficient and so productive here in VLA that we're nearing the finish line and we're almost there. So thank you to everybody for all the great work you're doing.
Yeah, we'll probably have to meet on unusual days next week with that Wednesday session. So just keep watching emails and stuff. we're definitely Monday, and then I can't remember after that. We have to adjust with that new session date. All right. Anything else?
I just chuckle at enjoy your day off. What is that?
Yeah, seriously.
It doesn't exist for those of us with businesses, right, Brad?
All right.
All
Good
right.
job, all.
All right. We'll see you later. Have a good one. We'll adjourn for the day.